But under much humiliation,
Yes.
as well as my lord, under extreme urgency.
Yes.
Mentioning a matter, my lord, lordship's the construction will be demolished, my lord, by tomorrow.
Construction.
By the barrack 2 weeks back, not barrack 2 weeks back. That
So-
is, my lord, lordship.
So you have filed an appeal 218 subsection 3. Stay rejected.
They rejected by the appeal court.
Stay rejected by the appeal
Yes,
court.
that, my lord, we have come up here.
File it, it will appear.
But,
My lord,
It is appearing.
yes,
What is the item number?
664 of the monthly.
664. Why did not mention? Monthly list.
But if your lordship kindly,
What is the notice of the, when the notice of demolition was?
my lord, to by tomorrow, my lord, they will break up the demolish the construction.
All right, hand over the slip. Mention the urgency, hand over the slip.
my lord,
So the lordship, my lord, kindly pass a limited interim order.
So who is appearing for the other side?
We have served notice.
Who is the landed advocate? Please inform him. I am keeping it tomorrow.
my lord,
Please inform him. ওইটা কালকে please hand over the slip.
my lord, may I be permitted to mention?
কালকে
নামগুলো লিখে দিন আছে
দেখছি আপনি এ করে মার্ক করে রাখুন তো ভালো।
My lord, for release, my lord, as the matter pertains to the determination of court number 25, my lord,
Section 24.
section 24.
About the slip to be mentioned.
Extension,
Section 24.
extension of interim order.
Extension of interim order, please hand over the slip.
My lord, extension of interim order.
Hand over the slip, extension of interim order. Yes.
My lord, may I be permitted to mention one item appearing in the monthly list, serial 117. My
What
lord,
do you want?
for upgradation, my lord.
Can you not wait till Wednesday?
My lord,
Yes, yes,
my
Mr.
lord, my
Banerjee.
lord, it is on extreme urgent. It is already, it is filed
You
in the.
cannot wait till next Wednesday. That is why I'm asking you. You know the urgency much better than me. That is why I'm asking you. I'm leaving it to you. Can you wait till Wednesday? Yes.
Lord,
Yes,
three
Mr. Banerjee.
contested applications, my lord, which involve Bengal Agra Assam Act, because my lord, the appeal was ought to have been preferred, my lord, from the interim order, my lord, before your lordship's court was preferred, my lord, before the learned district judge. My lord, we are under radar, my lord, because of my lord, this interim order. My lord was kind enough, my lord, to take up the matter to express my lord's view, my lord, which was my lord, apparently in our favor. Now, my lord, radar permission is going to, my lord, expire. My lord, we are getting it extended day by day. Now, my lord, every day, my lord, counts. My lord, the matters are
Banerjee,
not
before
there in the
vacation,
list.
it's difficult.
My lord, it will
Please.
take only a minute's time, my lord, a moment's time for
Mr.
you.
Banerjee, I'm not entertaining any contested application. That's the difficulty. I cannot single out one matter. That's the, please,
My lord, three projects will suffer, my lord. If radar does not give us, my lord, extension,
contested application, it's difficult, Mr. Banerjee, because I'm not entertaining any contested application. That's the difficulty. Yes.
My lord, extension of interim order.
Please hand over the slip extension of interim order. Yes. Please call them at.
Item number 1,
Yes.
That matter, my lord, when that inquiry with regard to valuation, we have made an application in pursuant to your lordship's leave. Matter was
Oh.
taken up, my lord, Mr. Mukherjee was appearing.
it was-
Your lordship was kind enough to.
On the last occasion, my lord, there was an option given to me to either to delete the prayer F or to pay 50,000 rupees as a court fee. So, my lord, the instruction from the client is that we are ready to delete the prayer F.
Yes.
Yes, my lord.
But
And that means, but the written instruction is on record. my lord.
keep it with you because that might be in future.
Lordship.
You understand why I have
Lord, I
asked you to.
understand, Lord, that we are conceding to Lord deletion of a prayer, Lord, that's the
That's-
reason it requires.
That is, or I can do one thing, Mr. Mukherjee.
My lord.
I can give you liberty to file an application before the launch. I think that will be better.
But your lordship kindly records it, why I say it. But this is a suit, Lord, of ages. But I'll also pray for Lord, expeditious disposal of this. But your
No,
lordship.
I do not have anything in taking your, in accepting your submission, but
I'll not
what
be
will
pressing for
happen thereafter, I do
So
not
that
know.
prayer, Lord, I am not entitled to, Lord, a degree on that.
That, Mr. Mukherjee, you are now saying, nobody knows what may happen after
We have,
that.
Lord, apprised the client has understood, Lord, and then, Lord, he has given the written instruction.
Yes, then what you have?
Your lordship I leave it to your lordship
No,
because
if they delete that prayer, what is your submission then?
if he abandon a particular prayer, my lord,
Prayer F, please go through
Yes.
prayer F only. He is abandoning only prayer F.
yes. my lord.
So if he abandons only prayer F, then that cancellation
But
part goes.
prayer F is consequential, or rather prayer E, F, all are related, my lord.
So delivery of and cancellation is going to section 31, which is not permissible. Otherwise, I'm entitled to a declaration under 30.
Mr. Shamul, only one thing, cancellation he is withdrawing, not the other prayers. Please apply your mind.
My lord.
Because he is only giving up cancellation because cancellation part is a difficult thing. If cancellation is paid for, it has to be according to the market value or the value as mentioned in the deed. So he is giving up. So now if he gives up, then he squarely comes within Surit Singh. Because though the learned trial judge has referred to Surit Singh, relied upon, but there is a distinction. In that case, there was no prayer.
No prayer.
Here, there is a prayer. Now, Mr. Mukherjee wants to delete that prayer. So, if he deletes that, it squarely covers under Surit Singh. Earlier, it was not covered, though he got an order on based on Surit Singh. So, now what is your submission on that? If he wants to delete that, please apply your mind. He is only deleting prayer F, not other prayers.
Prayer E, well, it kindly comes prayer E for a declaration that a purported lease deed executed and registered by original defendant number in favor of defendant number 2 is
That will
void
remain. That
and
is
remain and not binding on the plaintiff and other co-petitioners.
yes.
Next prayer,
Yes.
declaration under mandatory injunction calling upon the original defendant and jointly and severally return and cancel the lease deed dated such
That
and
is
such-
section 31.
Right.
So section 31, he is withdrawing that.
Right.
Or he is not pressing, deleting that. Prayer he will remain.
My lord. But he challenges the execution in prayer E.
If he, you can take
And-
all points will be left open. If his suit gets dismissed on that for not making that he will take,
I'll take the risk.
you will take that risk. Yes, Ashun. This application under Article 227 of the Constitution. এটাকে ফেরত দিয়ে দিই। Yes, call the next matter.
Agenda number 2.
My lord, I beg to address your lordship, my lord, on virtual mode, my lord.
Yes.
The interim order, my lord, which was there in the matter, my lord, expires, my lord, with the end of August. Therefore, we have made, my lord, a mention before your lordship, my lord, for an extension. This is an appeal in connection with an order of demolition under the West Bengal Municipal Act. The appellate court initially did not grant stay. Being agreed, we came up and a limited order was made by your lordship.
Appeal. You are for the,
I'm for the opposite party number 5, my lord.
you are the complainant.
Complainant opposite.
Directing, instead of keeping it pending, and directing the miscellaneous appeal to be disposed of.
My lord, date for hearing of the appeal, my lord.
All right.
I have prayer, my lord. One is the coordinate bench has extended this order till 11th of September. If my lord extends the order, my lord, kindly do not extend the order beyond 11th of September, and today is the date for hearing of the appeal.
All right, madam, only one thing. I am directing the miscellaneous appeal to be disposed of. Till that time, since this interim order is continuing, I am extending till the disposal. I am directing the miscellaneous appeal to be disposed of by the end of September.
Obliged.
My lord, it's
By the end of September, 1 month.
Obliged.
Ashun, this application under Article 227 of the Constitution of India. Acha, তার আগে লিখুন, though this matter is appearing under the heading extension of interim order, with the consent of the learned advocates for the respective parties, this matter is taken up for hearing by treating the same as on the day's list with the consent of the learned advocates for the respective parties. First of this application under Article 227 of the Constitution of India is at the instance of Mr. Banerjee, you are the owner of the impugned construction.
My lord, my lord.
This application under Article 227 of the Constitution of India is at the instance of the owner of the impugned construction.
Developer.
You are the developer.
Yes.
Is at the instance of the developer of an impugned construction and is directed against an order being number 13 dated 6th of June 2024 passed by the learned civil judge junior division first court of Sirampur in this appeal number 4 of 2023. Full stop. Paragraph. By the order impugned, the prayer of the petitioner for stay of operation of the order of demolition dated 16th of February 2022 passed by the Uttarpara Kotrang municipality stood rejected. Full stop. Mr. Banerjee, learned senior advocate appealing for the petitioner submits that the petitioner has challenged the order of demolition passed by the municipality by filing a statutory appeal under section 218 within bracket 3 of the West Bengal Municipal Act 1993. First of all, he submits that unless an interim order is passed, the appeal would become infructuous. First up, paragraph. The learned advocate appealing for the you are for the municipality. The learned advocate appealing for the opposite party number 5 submits that the petitioner had made an illegal construction for which the municipality passed an order of demolition. First up, she submits that the an illegal construction should not be allowed to remain even for a moment. First up, she however submits that the appeal, that the miscellaneous appeal is otherwise ready for hearing, and today is the date, and today is the date fixed for today. Bole aajker date ta likhe deben. Today, that is such and such, is the date fixed for hearing of the appeal, and a direction be passed for an expeditious hearing of the said miscellaneous appeal. First up, heard the learned advocate appealing for the municipality. First up, paragraph. Where is the order of demolition, Mr. Banerjee?
Lord, it's there.
Have you annexed or you have not annexed?
Order demolition, but we had to do this under some.
Heard the learned advocates for the parties and peruse the materials placed. First up, the petitioner has approached the learned civil judge within bracket junior division first court at Sirampur by filing a miscellaneous appeal being number 4 of 2023 challenging by filing a miscellaneous appeal being number under the provisions of section 218 within bracket 3 of the 1993 act challenging the order of demolition dated 16th of February 2022 passed by the Uttarpara Kotrang municipality. First up, since the appeal is otherwise ready for hearing and a date has already been fixed for hearing of such appeal, this court is inclined to extend the interim order past. The interim order is subsisting.
Yes, my lord, 15th May it was passed, 15th May 2025.
Subsisting interim order till the disposal of the miscellaneous appeal. First up, paragraph. In the light of the submissions made by the learned advocates for the respective parties, CO number such and such stands disposed of by requesting the learned civil judge, junior division, first court at Sirampur, to take up the hearing of the miscellaneous appeal and to make an endeavor to dispose of the same as expeditiously as possible, but preferably by the end of the month of September 2025 without granting any unnecessary adjournment to either of the parties. First up, this order has been passed. The time limit has been fixed, taking note of the fact that the appeal arises out of an order of demolition and the same is pending from the year 2023. First up, the subsisting interim order is extended till the disposal of the miscellaneous appeal number 4 of 2023.
Obliged. Deeply obliged. Sorry, I can't hear my learned sister.
Not of September, I've said by the end of September. Without granting, that I've said. Can shop dispose of করে দিন. In the light of this order, shop can গুলো dispose of করে দিন. Yes, next.
Obliged, Your Lordship.
Lord, I appeal for the petition, Lord.
Yes.
So challenging this revision application is the order and passed under 672 of H premises tenancy act. My lord, the application has been disposed of keeping the pending dispute of landlord-tenant relationship to be adjudicated at the time of trial, my lord.
So who is appearing for the other side? Have you served?
Yes, my lord, notice has been served, my lord.
Where is the affidavit service?
My lord, notice, affidavit of service has already been filed, my lord, on an earlier occasion, my lord.
So you have filed an application for extension, 1 of 2025.
My lord, it's running. It's the interim order is running, my lord.
No. This application you have filed, you have filed for extension?
No, my lord, it's at their instance, my lord, seeking for expeditious disposal of this revisional application, my lord.
Oh. This matter is appearing under the heading.
Two suits, my lord.
Same.
Same.
You have served.
My lord.
Same. Same order. Next.
Item number 5.
Yes.
Grateful, my lord.
Lordship, I appear for the petitioner. My interim order expires at the end of August, Your Lordship.
Yes.
The interim order was passed on extended on 23rd of
Have you
May.
sought upon the other side?
No, Lordship.
Then-
Before mentioning this time, we did not serve, but the petition is.
4 times you have already served.
Maybe, sir, can you not serve? An advocate has entered appearance. Please serve. Yes,
Come back after. sir.
tomorrow. Yes, next.
Item number 6.
Yes, yes.
My lord, pursuant to the direction passed by this honorable court, my lord, I served copy upon the opposite party, but the service has not been effected, my lord. It has come back.
Service has not been affected.
It has come back
Then
with,
interim order cannot be extended, Mr.
my lord, came back with the remark, my lord, address cannot be located.
Then
Well,
you
let
do
me
not
serve-
know where your opposite party is
No, no,
staying.
I served, my lord, pursuant to the, no, my lord, as my lord described in the plaint of the suit. But let me serve upon the opposite party as well upon the learned advocate for the opposite party in the court.
Mr.
Within half an hour, my lord, I am
যদি
supplying.
না দেয় এটা রেকর্ড করবেন না কিন্তু
না, আমি
এক্সটেনশন
করে দিচ্ছি।
মার্ক করে রাখুন আলাদা করে You are for the respondent.
Opposite party, my lord.
You are for the petitioner. Yes, Mr. Rai.
Extension, my lord.
Yes, what is the impugned order? What is the impugned order?
Refusing to grant an order of injunction
Junction?
at the courts below. If your lordship can consider the order passed by the municipal court below, the order impugned.
Yes, madam, what do you say? With regard to the prayer for extension of interim order? Let it be extended, all right. The learned advocate appearing for the
In this case, my lord, I am for the petitioner. In this case, my lord, I am for the petitioner. And twice, my lord, the interim order, my lord, extended.
This matter is appearing under the heading extension of interim order. তাহলে ওটাকে আগস্ট থাকলে তো তাহলে interim order. The subsisting interim order.
Yes,
The
after August
subsisting
that
interim
will
order, where is your other side?
No, no, no. নিয়ে চলে গেছে।
তাহলে
আরে,
ছাড়েন, যা আছে ছেড়ে।
হ্যাঁ, বেরোবে না তো।
যা আছে ছেড়ে দিন, হ্যাঁ।
তখন গলা বেরোচ্ছিল।
Yes.
Item number 9.
No, no, I'm for the,
Your junior Mr. Rai is not going through the records.
but here's my video service.
Partition.
Yes. What is the short? Every matter is short. No matter is long for you. It requires time for the court to understand. Yes, yes. What is the
I'm for the defendant.
Yes.
My application for counterclaim, acceptance of counterclaim is rejected by the authority.
Acceptance of
Yes.
counterclaim.
Why yes, my written statement filed earlier.
Yes.
At the point of time when the plaint was filed,
When have you filed the application for
after filing of the written statement.
when?
At
What stage?
the stage of evidence.
Evidence, plaintiff evidence started.
Started.
Cannot be done.
Yes, my lord. Why I'm saying
Cannot
my
be
lord,
done.
in the plaint they have stated that they got the property by an deed which was not registered, but it was placed for registration.
Sir, 2020 volume 2 SCC Ashok Kumar Kalra's judgment. It says cut-off date is framing of issues. There is a concurring judgment by Justice Shantana Godar saying it can be till the starting of the evidence of the first witness of the plaintiff.
But lordship, the fact which was came before me, which was by evidence, by evidence of chief, it's not by tendering the evidence. At the time of chief, we came to know with the deed which they alleged to have been received, the property, and putting it in the into the lordship, the registration department, but not in registered.
No, show me the when the evidence started.
Evidence started. Yeah.
When the evidence started, Mr. Ghosh, the difficulty is because additional issues to be
April 2023, PW1 filed.
April 2023 PW
chief file,
chief file.
Yes.
Then
I filed my counterclaim on 13th June 2023.
13th June
2023.
23.
Yes.
No, in the meantime, any documents marked?
No, nothing. Only the evidence of chief has been filed. Document has not been tendered. And if you also can see just two paragraphs, I'll show just lordship.
All right, I'm extending requires hearing because as it stands on the basis of this judgment, subsequent judgment is also there, which says no, it is framing of issues is the last cut-off date. Because Mr. Ghosh, fresh issues are to be framed. It's not commencement of trial. There's a distinction between commencement of trial and this filing of, because in exceptional circumstances, if you can make out an exceptional circumstance, that has to be prior to the filing of the
But
chief.
the cause of action, which they alleged in the affidavit chief, has been arise after framing of the issue.
Then you cannot file counter claim. Then you cannot file counter claim.
Why I'm saying in the but I am required to challenge the deed which they alleged in the complaint.
Mr. Ghosh, you can challenge in other way. If cause of action is after framing of
The
issues,
cause of action hit back to the frame at the time of filing of the claim.
Mr. Ghosh, if the cause of action arises after framing of issues, you cannot file a counter claim. That's limitation. Order 8 Rule 6A.
May I submit?
Come,
Yeah.
I'm extending the interim order.
Short, very short.
Because if the cause of action is after that, you are gone.
But I come before you was under registration act. Because registration was done subsequently.
Maybe
it was placed for registration 3 years back. At the time of filing of the claim, it was placed for registration.
The interim order is subsisting.
Yes.
The subsisting interim order. Call the next matter. Yes. Yes, Mr. Raj.
This is the evidence service, my lord. That
Yes,
is
sir, within time. Then I'm extending.
This one is for the CAN, and another is for the revision application. Two evidence services are there. না দিতে হবে কনফার্ম করা হয়েছে আর আমাকে কোয়ারি করতে দিয়ে দাও yeah this question cropped up before your lordship on the date of admission also.
All right. The
Whether this leave
the
can
hearing the learned
constitute
advocate for the respective parties
affidavit service affected, my lord.
If a service filed in court today is taken on record,
Interim order is up to the month of August, end of August 2020.
yes, have you served?
Yes, I have served upon them, but the first one service, it is door lock, intimation served upon them. Second one, for the want of husband's name, the father's name, wife is related to the maintenance case. Wife is now at his father's house. She is a working lady at UP. Now, working lady as UP, under the UP government. I have served, I will-
Service affected.
Service, none of the services affected.
Why?
One is, when we see the intimation, the door locked, intimation served, first one. It is
Yes.
the address at Bihar. And second one is the local address where also it is not served.
The learned advocate appearing for the
What will be
petitioner's
extended, I-
service.
The opposite party.
Yes.
My lord,
Theoretically take up tomorrow, my lord, the copy is up in the meantime.
my lord, by virtue of the order improved, my lord, the misappellate court, my lord, basically my rejected my prayer. My lord, filed two applications. One is, my lord, under order 39 rule 7, my lord, praying for, my lord, advocate commissioner's appointment. And my lord, the second one, which is
Why miscellaneous appeal? Injunction. Injunction.
from injunction. My lord, there was an order of injunction of status quo with regard to nature, character, and my lord, position. Now, my lord, what happened, my lord? My lord, filed an application praying for, my lord, modification of the order to the extent that the defendant
The
can.
miscellaneous appeal has been disposed of.
Yes. Rejecting my prayer, my lord. My lord, my prayer was, my lord, twofold. My lord, by virtue of the first application, my lord, I sought for, my lord, injunction with regard to, my lord, the defendant, so that they cannot, my lord, restraining them from, my lord, interfering in my repairing work. And, my lord, the second one was, my lord, the prayer for, my lord, uh, order 39 rule 7, my lord, for appointment of advocate commissioner. So, my lord, order 39 rule 7 application, my lord, was rejected. My lord, the misappellate court was of the view that it is not an appellable order, it is a revisable order. My lord, I understand. So far as, my lord, the second prayer is concerned, that the defendants may be restrained with interfering with my repairing work, that has been turned down, my lord, on a ground. Lordship kindly sees, my lord, the misappellate court's, my lord, order.
So Chakraborty, then give him a copy.
Yes, my lord, I can give. My lord, Lordship, my lord, let it be, my lord, at the top. My lord, otherwise I will suffer. I will suffer, my lord.
It is at the top, Mr. Chakraborty.
If it goes down, my lord, then, my lord, I will suffer, my lord.
Item number 14.
My lord, item number 14, 15, and 16 are analogous matters, your lordship. I beg to appear for the petitioner, my lord.
Yes.
Lord, before your lordship enters into merit of the case, there is a similar civil revision application which is pending because of defective, your lordship. Lordship, I humbly
Pending?
for filing, your lordship, it is defective. It was tagged together, your lordship. I'm only humbly praying for one.
What is the order impugned?
Lordship,
The
the order.
order is not defective.
No, lordship.
Proceed with this matter. Yes.
Lordship, an order passed by the District Consumer Disputes Redressal Commission has been challenged, your lordship. An order of execution was passed under Order 21, Rule 38 of the CPC, your lordship. Lordship, there was a final order was passed on 28th of October 2015, against which the decree holder, your lordship, prayed for a execution application being 369 of 2015, your lordship, against which I have challenged it, your lordship, and an execution warrant was issued. Lordship, that I have challenged by way of this particular civil revision application, stating that the original petition, the main ground that was taken by them was of fraud, was of cheating, your lordship. My main contention, your lordship, is that the consumer forum is not the appropriate authority to decide whether there was any case of cheating, fraud, or bribery. Now, the execution
You challenge that order before in appeal.
Lordship, we shall challenge that, your lordship, but in the meantime, an execution warrant has been issued, your lordship. Lordship, kindly grant me a week's
When
time.
the order was passed by the District Consumer Redressal Commission?
On 3rd of June, your lordship.
No, that is the execution, the main order, parent order.
28th of October, your lordship.
So,
lordship, in the meantime, there is one more contention, lordship. In the meantime, the judgment debtors were never communicated the copy of the order. It was only after the execution
you did
warrant.
not contest the proceeding.
No, your lordship, that is the main problem, your lordship. We were not given any intimation. That is the main issue. We have not.
Where is the order passed in the original order that you have not annexed?
Lordship, that has been annexed as in.
Where? You have not annexed. The original order passed by the District Consumer.
Lordship, I have craved leave because I do not have the copy of that order, because I could not contest. I could not contest the original one. I have only got.
Maybe you could have obtained the certified copy. What are you saying?
Lordship, in the meantime, I could not, your lordship. I have only got information regarding the execution warrant. Lordship, kindly 1 week time, your lordship. 1 week, lordship.
The learned advocate.
Analogous,
Item number 15.
15, 16, same order. Next.
Great.
14, 15, 16, same order. Next.
Item number 17.
No, 17, I pray for not today, my lord. I am led by Mr. Mitra. Jayanta Mitra is not in Kolkata today. He'll come on tomorrow.
Mr. Banerjee, if it is
John, my only not today, my lord.
No.
My lord, only not today, my lord.
Please start.
My lord, only not today, my lord. Madam, my lord, client has entrusted him with regard
On the
to
prayer of the learned. Call item number 18, yes.
My lord, in that matter, I am appearing for the petitioner, my lord. This is for the expeditious hearing, my lord.
Expeditious hearing of what?
Come before your lordship for the order dated 14 January 2025, my lord.
Expeditious hearing of what?
Expeditious hearing of the suit for eviction. My lord, I have annexed in page number 9, that is suit for eviction and recovery of khas possession. I have filed this application, my lord.
What is the application dated 29th of August 2023? What is that?
Yes, my lord. Yes, my lord. This is the ex parte vacating application along with the Order 7 Rule 1111 hearing. That is also dismissed, my lord.
What is dismissed?
My lord, they have not filed in proper form, that is in affidavit, as well as they are not pursuing with that order or with that application. For that reason, the application has been dismissed.
So this 29th of August 2023 has been dismissed.
Yes, my lord.
Now what is the stage of the suit? What happened after?
My lord,
after 16th of April, what happened?
Yes.
You have not annexed the subsequent order sheets.
My lord, this is the last order which I obtained from the online. My lord, kindly come.
This application under Article 227 of the Constitution of
And then you also have.
Yes. Yes, Mr. Ghosh.
Is not the subject matter challenge is not refusal to grant stay by the appellate authority in a work of
Refusal to grant stay of an order of injunction.
no, not order of injunction.
So stay of what?
Stay that not the by order, the earlier order, the board not discharge the Matwalis on the ground that they have sold the work of property, initially recorded their names in the personal capacity and sold it. So all the Lord successors in interest of the Wakif, they did it. Thereafter, a proceeding was initiated, inquiry was made, and Lordship kindly come to the order by this order, page 15 of volume 1.
Yes.
Lord, your Lordship will get the relevant page at page 16, the second paragraph.
Yes.
Lord, by several deeds, all the Lord heirs, they have sold the huge property of the work of estate. Accordingly, Lord, the existing two Matwalis, that is 3 and 4, opposite party number were removed. And the board itself took charge of the work of. Thereafter, Lord, the two of the family members who are also guilty with the same offense, they applied for being appointed as Matwali. The next board, Lord, appointed them as Matwali, ignoring that they are also guilty of the same offense. They also sold. Lord, by deed, it has been mentioned in paragraph page 16, paragraph.
Yes.
Lord, they are Mintu Mondol and
Now, what have you challenged?
Lord,
what have you challenged?
This order was challenged. Lord, the next order.
Oh, you have challenged this order?
No. This order we have not challenged.
All right.
Next page 27.
So, as it appears at present, no suitable person is available for appointment as Mutwali.
Yes.
So, discussion, it is resolved, work of estate be assumed under the direct management of the. So, board took charge.
Lord, yes, we had no grievance.
Yes.
Lord,
Then what happened?
Kindly come to page 23.
23, yes.
Lord, 23, your Lordship kindly see that now this the next board on the application of these two persons, opposite party number 5 and 6, they have been appointed. We have challenged this order. Lord, on the ground that misappropriation of the property.
Where which portion records that they have been appointed?
Lord,
Page,
Lord, 27. This board has not taken into account.
Record the two applicants, Mintu Mondol and Mubarak Mondol as Mutwalis.
Yes. They have been not appointed by this order.
Yes, so you have challenged this.
This in Lord.
Who are you?
Lord, I am the complainant.
Yes.
I am the management of the masjid. Lord, then Lord, against this order, the persons who are removed, they have also filed an OA before the tribunal. That is pending. And Lord, this order, by the removal order, they challenge removal order. Now, in the meantime, this order has been passed. Lord, we have challenged this order. When on the same offense, two have been removed, who are also guilty of the same offense, they have been appointed. This is our matter of challenge.
Mr. Ghosh, by the initial order, by the initial order, Mintu Mondol and Mubarak was also removed.
Yes.
They were also removed.
No.
By the initial order, who were removed?
Initial order.
Yes,
Lord,
who were removed?
3 and 4.
What are that?
3 and 4.
What is the name of?
Lord, I am saying.
That is Sophia Rahman and Mumtaz Mondol.
Yes.
They were removed.
They are removed. And Lord, at the same time, your Lordship kindly come to page 16. The Mubarak Ali Mondol and Mintu Mondol, they have also sold.
Mubarak and
Mintu. Mintu Mondol, the paragraph, third line. Mintu Mondol. 3.
3 is Mubarak. Where is Mintu?
Lord, Mintu is the last third line.
Yes, Mintu Mondol.
Lord, these two persons have also sold the property.
Yes.
Lord, now on their application, ignoring this order.
We have challenged this order before the tribunal. What did the tribunal say?
Tribunal says that at this stage I am not going to stay it. Because Lord, the 5 years period has not expired.
Where is the order?
Lord, your second volume, last page. Lord, board took charge for a period of 5 years. 5 years have not expired, and these two persons who are also guilty of same offense, they have been appointed.
Now, Mr. Ghosh, how can I stay this without hearing them? Because that will be amounting to allowing your civil division
Well,
application.
that I know, but in the appeal you can do it. No, it is not a,
No,
it is not an injunction application. But apparently it appears.
may not be injunction, but Mr. Ghosh, without hearing them, because if I stay, the effect is removing them from the Mutwali sheet. Without hearing them, so stay is of an injunction. What is the object? Object is final relief is being granted at the
That,
admission.
that I have considered, but in appeal case, in case of appeal, Lord, your lordship always in the first appeal
No,
without
in the appeal they have refused. Appeal there, it has been, appeal was a contested one.
No, the appeal has been
appeal has been disposed of, or
no, appeal has been filed. It is an application for interim order.
Mr.
Lord, in appeal, interim order ordinarily grants because of the fact that they have no authority, they have no eligibility. It is admitted.
What is the date fixed in the tribunal? Directing, have you served that in the tribunal, that copy?
Date fixed? No date has been fixed, Lord. And Lord, two things. The board has taken charge for 5 years. That has not expired. In the meantime, what prompted them to appoint 2 persons?
What is the date fixed before the tribunal? I appreciate that, but the only difficulty is
how they can be appointed for the same offense to have been removed.
Mr. Ghosh, I appreciate you have a very good case, but the only thing is that the at the interim stage, if this order is stayed, it will be amounting to allowing your civil at the appeal, not only the civil division application, because nothing remains to be decided in the appeal before the tribunal also. That will be allowed.
The appeal court, Lord, has made a mistake that they could have stayed it for the time being because Lord, the board has taken
What
charge.
is the next date in the tribunal? I can direct. Have you served that copy of the miscellaneous appeal?
Yes. That appeal, way.
Oh, what is the next date fixed, Mr.
Lord, way was filed, thereafter put up petition was filed and it was moved.
What is the next date fixed?
Next date fixed kabe hoye the?
Ad interim prayer is rejected.
Yes.
Maybe that is right because ad interim, though reasons has not been assigned, actually because it will be amounting to. So give me the date. I can direct the miscellaneous appeal to be. Please serve that.
Not 1 minute. Taking instructions.
All right. 12. Come with the instructions and please take steps for serving that so I can direct that to be heard out on that.
But on the explicit it is bad.
Of course, I appreciate everything, but
the
tribunal has not rejected your application, it has only rejected your ad interim prayer. Tribunal was also of the view that after hearing them it is to be passed. That approach has to be, that's the correct approach. Yes, next.
That is number 20.
Yes.
Our petitioner before Lord is a plaintiff of a title suit for declaration and permanent injunction. Melody, I done Lordship's attention. Melody in order 39, rule 1 and 2 was rejected, and the appeal was preferred, and appeal injunction order was passed. That is page 51, Lordship's drawing Lordship's attention. Page 51. Page 51. The interim order is passed by the appellate. Page 15, the operating portion of the order.
Page 51.
51.
Yes, miscellaneous appeal is allowed.
Miscellaneous appeal.
Restraint from interim injunction. Yes.
That order, that interim order is still in force. The pending of the interim order, the defendants trying to dispose the plaintiff. Now the plaintiffs come with the application order 6 rule 17. That was rejected on the score.
Show me your amendment application.
Copy the record. Melody, kindly see the order.
Show me the amendment application.
The amendment application is strongly been annexed.
Please give me a copy of the amendment application.
By this time, your lordships kindly see the order passed by the
yes
order
Order dated 7th August 2023. এটা তো?
You have got that?
Yes.
Give me.
Wrong limit did not been annexed. Copy আছে তো?
No, this is the written objection. Where is the application?
No, sorry. Not this is. This. অ্যানেক্সে বাদ দিয়ে করেছেন।
Who are you?
I am the plaintiff.
Was this application considered or any other application? This has nothing to do with the injunction.
Injunction running. During pending of the injunction proceedings, the defendants trying to dispose my client, plaintiff, then come before this court with the order 6 rule 17.
Where is that ever means? Please show me that. Please
But your lordship,
look at the application.
but your lordship kindly see the order. Order itself.
See the application first. It may not be the same application which was rejected.
No, order 6 rule 17. ঠিক আছে।
Your allegation is that of encroachment.
Yes.
Subsequent to the passing of the order of injunction, there has been an encroachment.
Encroachment of 12-foot by passage that has not been mentioned in.
But you have not paid either mandatory injunction or recovery of possession.
No, that is true.
Then
that is not the recovery position at the time of filing suit.
Or mandatory injunction, because in the application for amendment, you have said that a wall has been constructed. So either you have to pay for mandatory injunction or recovery of possession. None of you.
No,
these
things for a moment. During pending of the
suit. Sorry, during the pendency of a suit, you are dispossessed. What's the law? You have to pay for recovery. That's the law.
That has not been paid.
Then
that has not been paid.
Order is right.
The lordship kindly see.
Order is right.
No, what's happened?
Sir, even if that is allowed, you will not get the relief.
Yeah.
It will be an infractious amendment application. Sir, the pleadings are to be incorporated for the purpose of some relief.
For
the purpose of some relief. You are not claiming any relief, sir. What is the use?
But in the impugned order itself, only things for a moment that the recovery position has not been paid for.
Yes, rightly.
I could assume. But subsequently, I made the application. For recalling the order that has not been dealt with the final order. That application I kindly appreciate, my lord. I join lordship's attention. This has been made. Well, that is page 36.
Page
36. The subsequent after that order, I made the application for recalling the order under fresh consideration.
No. Why it will be freshly considered? Have you filed any other application?
Yes, that is my lord.
Where is that?
Page 36.
No. Have you paid for recovery of possession in that?
No.
Then
recovery position made plain
so
is not.
Why it will be recalled? Why it will be recalled?
My lord, that is my lord, the things my lord, original plaint is filed my lord, title suit for declaration and injunction, permanent injunction. Now the during injunction order is there, pending injunction proceedings.
Sir, what is the law? If during the pendency of a subsistence of an order of injunction, if there has been an encroachment or disposition,
If I plead for recovery of position, the nature of the suit will be changed.
then
That is,
if that is so, amendment cannot be allowed on your whole saying.
that's
Cannot
why,
be, sir, cannot be allowed.
that's
What
why,
are you saying?
then what we have.
Sir, for that you have to advise your.
Now, they kindly
This-
appreciate to their liberty we give.
No.
So
What
that
liberty?
liberty for further.
That
liberty should be given. Otherwise, my lord, the client will pay.
this application under article, give me that লিখে দিন কি বললাম Yes, call the fixed man.
Item number 19.
Yes, Lord, we have ascertained, Lord, there no notice has yet been issued. We filed the put application, the date was fixed on 31st October. Your Lordship kindly see the last order, last sentence of the impugned order. That application has been
Oh,
rejected.
this was put up petition.
Yes, that's why your Lordship kindly direct that application to be heard upon notice to the other side on any date.
Which order says 31st of October?
No, that is not there here. Upon filing of the OA,
Yes.
next date was fixed on 31st of October.
All right.
But
So, copy is to be served by you or through the tribunal. What is the rule?
through tribunal.
Through tribunal.
Yes.
So I'm directing this application to be heard on 31st of October, to be taken up on 31st.
Not before that, we have been suffering.
Before that is puja vacation, Mr. Ghosh. 1 month, I think those will also be closed.
Within 2 weeks or 3 weeks, Lord, that application only
Because
thing.
unless it is served, Mr. Ghosh.
Lord, we shall serve. We shall serve.
No, you said that it is to be served by the tribunal. That is what
only
you said.
thing, Lord, that we shall place the requisites and they will issue it.
Yes.
Lord, your Lordship can see the last.
No, but only thing is that, Mr. Ghosh, I do not know for preponing what is the business of the tribunal. That
They have not been intimated as yet.
I'm not on the other side. The tribunal has to fix the date. So I do not know the diary of the tribunal. That's the difficulty.
That is usual.
Because I can do one thing. I can give you liberty to prepone, but that will be hearing other things. It will take because 1 month is vacation, Mr. Ghosh. That's the problem.
Lord, if your Lordship gives a direction, we shall try our luck by preponing the date. Lord, kindly see, Lord, this last sentence of the order.
Yes.
That application has been rejected.
What application?
The application made for interim stay.
Ad interim order is rejected.
No,
Staying.
No, petition filed today. However, the petition filed today, that is on 4th August 2020.
Where is the petition on 4th of August? Show me.
4th of August. City Center. Not registered.
Where is that application?
Yes, application. Yes. 29. 29 কি করে হবে? Yes.
70.
No, 75.
Yes, 75.
Yes. Yes, 75. Yes. Lord, your Lordship kindly come to prayer, page 91.
Yes, I'm at page 90.
He has made a mistake.
So resolution is stayed with an ad interim. The entire, according to you, the entire application is rejected, not only the ad interim prayer.
No, no. Lord, kindly see the impugned order last sentence.
This is, yes, so this is the application which was filed on 4th of August.
Yes.
Or the put up petition was filed on 4th.
Petition and this application.
I think put up petition was.
Put up petition along with this application.
Then you have to serve, Mr. Ghosh.
Then
Will delay. That was, I was trying to expedite that. Because in their absence, I cannot restore that stay application. That's the difficulty.
They could have refused the interim order, but as a whole, the application, because the prayer is that till disposal of the appeal, in the meantime to pass an order, interim order of stay.
By the order impugned, Call the next matter.
Number 21.
21, my lord. I am for the petitioner.
Yes.
That matter is for expeditious disposal of the suit, my lord. My lord, suit filed 15/12/2022. Opposite party appeared as defendant and took time on 12th February 2023. But my lord, they have filed a written statement of June 14, 2024. There are several occasions, my lord, due to lapses on the part of the bench clerk, 3 to 4 times the matter was adjourned, my lord. And since April 8, 2025, no date was given, my lord.
What happened? What is the difficulty with the bench clerk and the peon?
Yes, my lord, that is the internal part. They have make some posting of dates. That is why learned trial could show cause him, my lord.
What happened? What is the difficulty? What's the problem with the bench clerk?
My lord, since April 8, no date was given, my lord. This is a difficulty, my lord. Learned advocate in the trial.
The learned advocate appearing for the petitioner submits.
Two.
Yes.
My lord, this is against the impugned order of the Learned Industrial Tribunal, wherein he has fixed my matter ex parte, and I have filed a recalling application for vacation of the ex parte order.
Yes.
That has been rejected, my lord, and the fact is that I could not appear before the Industrial Tribunal to be absolutely candid for a period of 2 months.
Why?
That is, I am explaining, my lord. Technically, the service is good. I am not going to that. It is said that the intimation was served upon me and I didn't turn up. But actually, my lord, I have neither received the letter, notice, nor received the intimation. This is on the factual matrix that the petitioner number 1 is a 70 years aged lady, housewife. She is always at the residence. So there is almost no opportunity for missing the intimation or even the notice.
What is the dispute?
My lord, the dispute arises out of industrial tribunal dispute. My lord, one Mr. Devendra Kumar Duggar, he was the actual respondent in this matter. He was my father, the petitioner number 2's father, and once.
What is the next date fixed in the tribunal?
The next date, my lord, 8th September. On any stringent term.
Yes, who is appearing for the?
Not kindly state away comes to the impugned order.
Yes.
Not consumer forum, not in an execution proceeding, issues non-bailable warrant of arrest. Not Catena of judgment says, not it cannot be done. The section 71 of the act, my lord, has to follow the procedure under order 21. So, my lord, at the worst, my lord, I can be put before detention in civil prison.
What is the order which was passed by the in the original proceeding?
The original proceeding is a promoter.
Where is that order?
I'll just show one. Just give me a moment, Lord. But I have annexed all the orders of the Yes, well, the order is at page 73, final order and judgment.
Have you challenged this order?
No, my lord, we have not challenged. But my lord, only question here, my lord, there are judgments of the Honorable Supreme Court as well as our High Court, my lord, which says that, my lord, at best, my lord, bailable warrant of arrest can be issued. Your lordship knows under order 21, my lord, there is no question of a issuance of a non-bailable warrant of arrest.
All right, you secure this amount, deposit this amount.
I have been depositing certain amounts, my lord.
How much amount you have deposited?
Lord, I have been making payments as far as, my lord, but I cannot make a payment as a whole. Lord, that was the only contention.
How much you have paid? What is the
But
balance
14
amount?
lakhs have already been paid.
So, deposit the balance 18 lakhs. Sir, without that, money decree is operating. No stay.
Deepest of respect, my lord, if I may say, my lord, I may be put to civil prison, my lord. But, my lord, this, my lord, at the face of it, my lord, is bad, my lord.
Money degree, how can I stay that?
Supreme Court, my lord, says that this cannot be done. My lord, the coordinate bench of our High Court says
I can stay that provided you deposit this amount. Because ultimately it will be staying that money degree. Valuable warrant, the warrant part, I will stay that provided you secure this amount. Secure this amount, this judgment will be stayed.
But that, my lord, I can understand. But at a go, my lord, I cannot. If I could have, my lord, I would have not faced this
It is
situation.
operating since 2015. So with interest, now it has gone much higher than this. Please take instructions. How soon can you deposit? I will stay this. Deposit this amount. Not deposit, you have to pay because you have not challenged. So limitation is well over. So you are trying to.
Then, my lord, I have to argue the matter. Kindly hears me for a moment. My lordship will find another judgment. But in this same matter, my lord, where I had the occasion to appear, my lord. But there.
I will say that. No, you did not. But show me a decision which states that the money decree can be stayed without any
on that question. I appreciate following from your lordship, my lord. I know your lordship's view. No, order 41, rule 5 principles, your lordship. So, my lord, kindly appreciate.
I will say that, but I will on condition that we deposit this.
If today such a situation comes, your lordship knows, my lord, there are line of judgments where, my lord, I have an inability to pay. What would be the consequence? Or whether I should be put before the, my lord, rigorous imprisonment in a non-available warrant of arrest, that's the question. If I cannot pay at all, my lord, if that is the circumstance.
Is it your case that you cannot pay at all?
But as on today, my lord, that is the case. Otherwise,
that is the case. Without that, you cannot pay at all.
So that is why, my lord, I'm evading.
Saying that you are paying.
I have been making payment in tranches, whatever I can. But the entire decretal sum, my lord, if I could have paid, my lord, this would not have happened, my lord, today.
What is the dispute? What was the dispute?
The dispute is with regard to, my lord, delivery of flat. So, my lord, promoter, my lord, landowner dispute.
You are the promoter.
Well, lordship stays this for a, my lord.
You are the promoter. You are not carrying on any other project.
But as of now, my lord, it's not in a good position. That is what, my lord, lordship.
Because of all these.
Find from the paper.
Because of all this. Reputation is such.
That what is there is there, my lord. I cannot shy away, my lord. But for the time being, my lord, because, my lord, I was directed to file my affidavit of assets, my lord. My lord, let me comply with all those directions, my lord. If it is found that I have assets, my lord, it may be attached. But if I do not have assets,
some amount, show your bona fide.
That, my lord, I shall.
How much amount you can deposit?
Well, 2-3 lakhs, my lord.
Nothing. High Court.
Otherwise,
said that
sometime, my lord. Otherwise, that's the difficulty, my lord. All of a sudden, my lord, if I say, my lord, that's the difficulty, my lord. I'll pay in tranches, my lord. I was paying in tranches. At the end of the
instructions come at 2 p.m. How much you can pay? I will stay this. Provided you deposit that amount.
Not deposit, I'll pay it to him directly, my lord. Because in any event, my lord, there is no defense to my, because there is no appeal.
All right, that is a good gesture on your part.
No, so that is it. That is it. But only thing, my lord, I was on a question of law, whether, my lord, this non-bailable warrant of arrest could have been issued. Bailable warrant of
side that question of law may be in your favor, but subject to deposit of that amount.
Or not the entire amount, something, my lord, to be.
Sir, money decree.
But if I deposit everything, nothing remains, my lord. Then the entire proceeding goes, because then there cannot be any question of arrest or detention.
Or you take out an affidavit saying that you are unable to pay, then the consequences of that imprisonment, that will, from here on, I can pass that order. Perhaps then that money.
Then section 55 of the, my lord, CPC will come. Justice, whatever judgment would come, all those, my lord, things would come. But
so that is why then that money will come. So
money, my lord, I believe it should have come, but he's not in a position. My lord, this I know because I've been doing this matter from 2020 onwards. My lord, I have said to him before many courts, try and settle it.
Take instructions, how much, please increase your offer. 2-3, not commensurate in High Court.
I just check up, my lord, what is due, my lord, at least.
Yes, please check up what is due and how much you can deposit. Yes.
And only on the principal part, my lord. Only on the principal part, my lord. Not getting the interest as on date.
Item number 24.
Yes.
Behalf of the petitioner, appellant, defendant. My lord, the suit was filed by the opposite party, suit for declaration and injunction.
Yes, what is the order impugned?
My lord, order impugned is, my lord, during the subsistence of the no adverse order, my lord, resolution taken by the Bosirhat court, my lord, order has been passed on its merit. My section 5 application has been dismissed on merit, in spite of there being a resolution, my lord. This is the order impugned.
Ground, resolution.
My lord, client should not suffer, my lord, the catena of judgment. I have a judgment, my lord, which on similar facts, cost has been awarded.
Compensate the client. Compensate the client.
But client should not suffer, should not have been suffered, my lord. But categorically record there is a resolution in the past.
Compensate the client.
No.
Compensate the client.
My lord, I was
Yes,
not
come.
there before the trial court, my lord. My lord, order impugned, my lord,
That
at
be your
page number
counterpart
1.
was there.
My lord, say third paragraph, the learned
Section 5 in which?
in connection with first appeal.
So how is it a revisable order?
My lord, it's revisable order, my lord.
Who says?
But it's not, it has, that does not stand alone. My lord, our special bench judgment, Calcutta High Court judgment, my lord.
76 Calcutta.
76 Calcutta, my lord.
That has been over, sir. Yeah, 76 Calcutta 415.
My lord. 77, my lord. It's 415.
415. There is also a full bench judgment of the Odisha High Court, AIR 84 Odisha. That has been overruled in Pannalal Jaiswal
Kindly passes
2005.
an order so that it may be treated as an appeal, my lord. Kindly passes an order so that revision application may be treated as an appeal, my lord.
The second appeal will lie before this court. You have come before the appropriate,
my mistake.
in the appropriate building, but not at the appropriate court.
My lord.
Ashun, this application under Article 227 of the Constitution of
For the petitioner, my lord.
Yes.
Plaintiff is the petitioner before lordship suit for declaration of permanent injunction. Petitioner filed an application for local investigation because on the western side of the suit premises, he left some 100 square foot area land. Now the defendant
Local investigation
rejected on this form, my lord, that it is a joint property. Therefore, suit for declaration.
Show me the plaint.
It is page 9, my lord.
Who are you?
I am the plaintiff, petitioner. And course of the view, my lord, by reading of the plaint, it appears it is a joint family property. But nothing has been mentioned in the plaint that is joint property. And moreover, my lord, 2016, 2009 property is purchased. 2016, it is converted from agriculture to homestead land. It is demarcated portion I have purchased, my lord. No question of joint ownership.
No, not the joint ownership. The plaintiff say, you are saying that you are the exclusive owner.
Lordship,
Yes.
landed court is of the view it is joint property. Landed court is of the view it is a joint.
No, what is the defense case?
Defense case is same, my lord. They are saying, defense case saying it is a joint property. There are more than other co-sharers.
Then why local investigation? What for local investigation?
It is my exclusive property. I have purchased the property, demarcated property, western side of the said property. I have
Sir, why local investigation? What for?
measurement of the land, my lord.
Why?
Because they are claiming that is the western side of the property.
What they are claiming? That the defendant? Defendants are also claiming title in respect of the property.
But they are making boundary wall, my lord.
Where is that? Show me.
Page 20, my lord. That application. Paragraph 3, it is written in Bengali. বাদী আর্জিতে আরো উল্লেখ করিয়েছেন যে তা খ তফসিল ভূমি লাগোয়া পশ্চিমে বিবাদীগণে ভূমি অবস্থিত বটে। উক্ত বিবাদীগণ ক তফসিল মধ্য ছাড়িয়ে রাখিয়া খ তফসিলের উপর কনস্ট্রাকশন আদি করবে চেষ্টা করিয়া তা নিজে সামিল করিবার জন্য বাউন্ডারি দিয়ে ঘিরে দিবার চেষ্টা করিলে বাদী উপরোক্ত মোকদ্দমা আনয়ন করিয়াছেন। বিবাদীগণে তাহাদের বর্ণনাপত্রে খ তফসিল বর্ণিত ভূমি না থাকার বিষয়ে উল্লেখ করিয়াছেন। সেই কারণে খ তফসিলে স্মৃতিস্থল নির্ণয় করার জন্য আদালতে জনৈক পিডার সার্ভে পাস কমিশনার নিয়োগ করবে আদেশ দেওয়া আবশ্যক। নচেত বাদীগণে অপূরণীয় ক্ষতিসাধন হইবে। এমতে
Where is the written statement? Show me the written statement.
It is page 15, my lord, 15. Paragraph 4, my lord. নালিশি সম্পত্তি বাদীগণের যে খ তফসিল এবং গ তফসিল ক এবং খ তফসিল বর্ণিত ভাগ উল্লেখ করেছেন তা অবধি কোনো ভাগ সরেজমিনে নাই। নালিশি থেকে টোটাল পরিমাণ 94 শতক বাদীগণ নিজ ইচ্ছে মতো একটি 8 শতকে চৌহদ্দি দিয়া
Where is the sketch map?
My lord, I have made an application for conversion of the same and BLR has really converted the sketch map. Your lordship, I couldn't annex it.
No, have you given any sketch map in the plane? No.
In the plane, no, my lord.
By the order impugned, the application under Order 26 Rule 9 of the Code of Civil Procedure stood rejected. Full stop.
Item number 26.
Yes.
For expeditious disposal, I am for the plaintiff petitioner suit of 2004.
You are responsible for the delay.
My lord, 2004 suit, my lord. This is
How many resolutions of the local bar association was there?
There is, my lord. There is.
Then,
My direct, my lord, 2004 suit, my lord.
even if there is a resolution, it will proceed. So both the things cannot go. together.
2004 suit, my lord. 2004 suit, my lord.
Maybe. How many resolutions? Last day was a resolution.
Yes, yes.
Yes.
Kindly expedite that.
Acceptance of cause.
Cause of the defendant number 1.
Why?
Wait for expert hearing. Dependent filed written statement, therefore order 6 rule 17 was allowed.
Written statement filed.
Yes, written statement filed, therefore application for order 6 rule 17 was allowed by the dependent, my lord.
This application under Article 227.
Arising out of an order.
Yes.
Order of visitation, my lord. Kindly comes to the order.
Mr. Lahiri, do I have any difficulty in taking up this on Baripur court?
No, no, no.
You have ascertained.
I'll again ascertain and come. Just kindly passes it over for some time, my lord.
Please
10
ascertain.
minutes. 10 minutes.
Yes, call the next
Item number
matter.
28.
Petitioner is the plaintiff petitioner. My lord, the application, my lord, the application for my lord, the injunction was granted. My lord, thereafter, my lord, I filed an application for 151 for implementation of this injunction order. Injunction was contested one. The order was not been challenged before by the defendant. My lord, the court was earlier rejected my application. I moved a revision application before this honorable court. This honorable court, my lord, set aside the order and directed to rehear the matter. My lord, after hearing, my lord, again, my lord, the order, my lord, the application was rejected on the ground. My lord, you will also kindly see that ground, my lord.
Where is the order of injunction? Show me
Well,
that.
that is that, my lord, page. My lord, I have a copy, my lord, I have annexed the legible copy also, page 19, my lord.
19.
19.
19. 19 is the application. এটা কি দিলেন? কোন ফাইল দিলেন? One nine.
19. Legible copy, my lord, annexed.
The defendants are restrained from disturbing the plaintiff or the suit property and also directed to the maintain the status quo with regard to the nature.
Yes, Mr. Bhattacharya, who is appearing before the learned trial judge? Who are the advocates?
Take instruction.
You have taken instructions, Mr. Bhattacharya. Yes, pass over next.
That was not Baripur, Barasat. My matter is from Barasat.
তাহলে কি এটা দিয়েছিলেন আপনি
Other
আগেরবারে?
file
was given. I think his matter was. Passing it over. Let's yes, next.
Item number 29.
My lord, I am for the petitioner, my lord. My lord, this is probate proceeding, my lord.
Yes.
I have the instruction to appear on the opposite party, my lord.
Yes.
Although there is no caveat, my lord.
There is no caveat. What is the impugned order?
My lord, impugned order, my lord. Last two orders passed in the probate proceeding, my lord. One is of 15th July 2025. Another is 2nd, my lord, August 2025, my lord. My lord, when the evidence, my lord, was fixed in the year 2016, my lord. Now the
2nd of August 2025.
My lord, two orders, 76, order number 76, that is 15/7/2025.
For further cross-examination.
Nobody prays for time, my lord.
Neither the further cross-examination, PW acceptance of the written statement.
Even the written statement was not accepted, my lord. Although the petitioner raised no.
Why are we agreed?
My lord, there is, my lord. This is now cross-examination of the petitioner is going on, my lord.
Yes. What do you want?
He's on. My lord, essentially my prayer, my lord, to expedite the matter. Although there is an order initially passed by my lord Justice Shompa Sarkar, and thereafter my lord once considered this matter, my lord. My lord, can you consider page number 45 once, my lord? My lord Justice Shompa Sarkar, my lord, directed the learned trial judge, my lord, on 30th August 2023, my lord, to dispose of the interlocutory application within 3 months, my lord, from the next date, and thereafter within a year to dispose of the probate proceeding, my lord. My lord, that was not done, my lord. In the month of March, my lord, before that, my lord, in 2024, my lord, after the expiry of that period, my lord, I filed another application, and that was taken by your lordship, my lord. Since my lord Justice Shompa Sarkar's order was there, my lord recorded that, my lord, that is at page 45. That since there is already there is an order, my lord, for that reason, my lord didn't interfere, my lord. Now the situation is different, my lord. Nobody, neither the petitioner nor the contesting, my lord, the party raised any objection to that, my lord. In spite of that, my lord, on both the occasion, my lord, the cross-examination of the PW1, my lord, was not done, my lord. Even the amended written statement, that was
the plaintiff or the defendant?
I am the plaintiff.
Yes, why are you not cross-examining him?
My instruction is that their court is vacant at present.
Court is vacant.
My lord, subsequent to
last 2 dates.
my lord, subsequent
or last
2 dates. That is my
is the court lying vacant? Yes or no?
My lord, yes. Presently, but at that time that was not there, my lord. It was fixed on 20th August, my lord. Now court is vacant, and my lord, they didn't appear before the judge in charge, my lord. And matter next is fixed on 29th of this month, my lord. And
the deciding officer has joined or not joined?
Not yet joined, my lord. Not yet joined, my lord. Kindly direct a charge. My lord, already there is a direction, my lord, from the my lord, there is a direction to issue notice. My lord, notice has been directed to be issued upon the opposite party since they have not appeared on 20th August 2025, my lord. Yes. For that reason, my lord. My lord, it is already there is a direction, my lord, that was considering that was, my lord, didn't interfere in the month of March, my lord. Now cross-examination, my lord, the evidence was, my lord, directed to be started in the year, my lord, 2016, my lord. My lord, kindly expedite, my lord. My lord, this is very innocuous prayer, my lord. This matter is pending for last 11 years, my lord. Initially, it was filed in 2014, my lord. They have 4 times they have filed written statement, my lord. Amended their written statement, my lord. In that juncture, my lord. Otherwise, my lord, this matter will be go on like this, my lord. There will be, my lord, my client will be prejudiced, my lord. My lord, kindly consider this aspect, my lord, kindly direct, because already, my lord, judge in charge has directed us to issue a notice since they have not appeared on 20th, my lord. 29th is the date fixed, my lord. If the cross-examination of, my lord, PW1 is concluded, then the matter can be disposed of, my lord. Already that direction is there by, my lord, Justice Shampar Sarkar.
Yes.
2 years back, my
Sir,
lord.
that is not such an innocuous prayer, my lord. May I just show before your lordship? My lord, this 11 years journey is not stalled because of his 16 adjournment being prayed for over there. Once the order of eviction is being confirmed up to the Honorable Supreme Court, the Lordship now is familiar with the cause title of this matter. Now he wants, my lord, on the last day when your Lordship passed an order after Justice Sarkar's order, your Lordship made it clear that this will not preclude me to file an application, my lord, challenging an application, my lord, for rejection of Order 14 Rule 2. Because my Order 14 Rule 2 is being rejected. Kindly takes up my lord's order on 6th of March 2025.
Page 45.
Lord, I have
onwards,
not
my-
been served with the copy.
My lord, page 45 onwards, my lord.
Very well.
My lord's order 47 at page 47 and 48, my lord.
48.
47 and 48.
Lord, kindly takes up that paragraph. Lord, it starts with Mr. Mukherjee, learned advocate. Has your lordship got it, my lord?
My lord, I'm sorry, this is 49. This is 49, my lord. My lord's order is at 49.
Yes. Lord, page 50, then your lordship will get this. Lord, Mr. Mukherjee, learned advocate appearing for the opposite party submits that on that day the application under 14 Order 14 Rule 2 stood dismissed, and the opposite party is contemplating challenging the same before this court by filing an application under Article 227. This application has been thereafter filed, moved once before your lordship. One of the learned advocate represents, senior learned advocate, my lord, representing the opposite party who once appeared for my client. He want, Lord, this has been disclosed before your lordship. On his prayer, the matter got adjourned for a single day. Thereafter, I also mentioned, my lord, for upgradation of this matter. So this is pending. So this is a deliberate attempt. Again, by filing another application for, my lord, expeditious.
That is their application, my lord. It is their.
Particularly, Mr.
That
Das also
application
mentioned for upgradation.
As a last application, my lord, I couldn't mention another application I have mentioned, my lord. In fact, I have communicated to Mr. Das, my lord, the learned advocate on record, my lord, for the opposite party.
He already mentioned that revisional application. So, my lord,
Why is the application challenging the order under Order 14?
My lord, that is appearing in my lord's list, today's list, my lord, at item number 206, 260, my lord. I stand corrected.
This application under Article 227 of the Constitution of India is at the instance of
This application has already been disposed of, my lord.
Which application?
My lord, this is the present application.
This server copy.
My lord, that I will do. That
At order record করে দিন তো। The learned advocate for the petitioner assures this court that the copy of the civil division application shall be served upon the learned advocate for the opposite party in course of this day.
Great. My lord, here and now I am.
I have recorded your assurance. I think Mr. Mukherjee will not dispute after. Yes.
27, this is arising of an order of visitation. Kindly comes to the order first and thereafter I'll be drawing your lordship's kind attention to the previous orders. Husband.
Father.
Yes, father. Father, husband.
Visitation denied.
No, given, but in court premises. It is, my lord, first there was an order by which, my lord, visitation rights were given by the court in Axis Mall. She didn't comply. I came up and said that kindly modify this order. She is not complying. I have given specific examples. Now that was modified to the extent that yes, there is a special officer and they will be coming. I had prayed for special officer, but the order was that the child will be produced in court. Didn't produce. Thereafter, again, I made an application that I may be granted opportunity to take the child out in Durga Puja, Kali Puja, and Diwali. Not complied. Thereafter, again, I have approached saying that there should be a special officer so that, my lord, the factum of production of the child is observed by the special officer. But, my lord, the court has directed that the special officer will be there, but the production, but the child will be produced in court. My lord, I am praying that kindly comes to
deciding.
My lord, Newtown. Newtown. Kindly comes to page 61. Kindly sees the first order.
No, where is the child is residing, Mr.
Newtown. Oh, Lake Town. I am in Newtown. They were residing in Newtown. Now they are in Dokindari, Lake Town. Kindly comes to page 61.
So what would be the convenient
Axis Mall. Kindly comes to page. These are
where?
Axis Mall is in Action Area 1, Rajarhat, Newtown.
No, somewhere near Lake Town.
Somewhere near Lake Town.
Where?
City Center. City Center 1. Kindly comes to page 61 first. And on 29th,
alright, Mr. Lahiri serves them because without serving it cannot be.
29th, it is her birthday. There are orders which were passed.
Lahiri, with expertly, this order cannot be modified, Mr. Lahiri. That's the difficulty.
Kindly visualizes this situation. There is an order already of production of the child in a mall which was not compliant. Order by which direction was given that during the Kali Puja and Durga Puja, I'll be able to take the child out. That is also.
No, last year's Durga Puja.
Last year. Not challenge, nothing. As of today, I'll be praying for the same order.
But let me, they have to stop Mr. Lahiri. Well, can it be expertly, Mr. Lahiri?
I understand, but before the, kindly sees, there is huge pressure on the court. I understand. Before that, if your lordship kindly keeps it, then it can be done in their presence. Kindly keeps it in the next week because 29th is her birthday. Next week, 29th September.
29th of September is it?
And my lord, 26th September. So therefore, Puja, Kali Puja, birthday, everything. So if it
where is your application which was disposed of by this order?
Yes, application 90, page 90. Page 93 would be paragraph 17 that as per the specific direction of the learned court on 26 at about such and such, the petitioner further came to the office of the Dalsa
to produce the child at such venue. What is the such venue?
Your lordship is in the ordering post. Yes.
Where is the such venue?
But such venue, lordship may kindly reads this with the orders dated 1st and my lord, orders dated 31st. Kindly comes to the order dated 1st. May I, my lord? The such venue has to be read.
Going through the impugned order, this court is of the prima facie view that the court premises may not be a suitable place for the visit
my lord. The matter can release, my lord. Page item not 28, my lord.
28
Number
has to be
28.
released. Should have taken instructions before I am Mr. Bhattacharya. This application, since I'm not in 28, since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this.
Number 30.
30, my lord, is my application.
Yes.
My lord, kindly come very short. Kindly come to page 24. A truck was taken on loan. Vehicle was taken on loan. Page 24 is the order of the learned city civil court. I want to pay the entire amount of one page 24. Order dated 7th April. It records that the OP will deposit total outstanding amount of 1,71,400 by 2nd May.
Yes.
And will continue. And my lord, thereafter, my lord, we had filed an application for modification saying that 1,71,400 may be modified to 5 installments. But the modification application could not be taken up for hearing. Kindly come to page 28. This is the account position as signed by
Now, what do you want now?
my lord, the 1,71,000, I'm carrying the check now. Earlier, I had applied for modification, then I may be given 5 installments. But unfortunately,
We approached the law on a trial.
we had approved modification, but just kindly, I am coming. Kindly come to the very last page. The modification application could not be taken up because the learned judge was not sitting. It went to the judge in charge, and the judge in charge had posted on 8th, 9th.
What is the order date of the order?
13th August.
8th of September.
Yeah, the next date is 8, 9. Judge in charge has posted. Now, what has happened? The sale application that now they are proceeding to arbitration. That the sale application it will be moved for arbitration on 2nd September. And I'm carrying the entire check of 1,71,000. And they have taken possession earlier, 1 month gone. But now they are not accepting the amount. Now they are going for sale. Everything will come in first.
So I'm giving you liberty to approach the law on a trial judge.
Before 2nd night.
To fix it prior to 2nd of September.
It can be here also. It can be finished.
It cannot be
We
taken
can serve and come back again.
Cannot be before 2nd of September.
Oh. Then kindly,
before 2nd
I understand the pressure on the court. That kindly pass on that it should be taken up before 2nd. And my modification application, which is pending, may be taken. Grateful.
Acha, arekta, yes. The learned advocate on record of the petition is directed to forward a copy of this thing. Oh. None appears for the petition at the time of call. No accommodation has been sought for either.
I'm led by Abhimanyu Banerjee. My lord, I'm praying for one week accommodation.
On the prayer of the learned advocate for the petition, hearing of the
application, my lord, where I have challenged an order which has been passed under section 17(3) of the old Tenancy Act, whereby my defense as the tenant has been struck off, my lord. My lord, on the wrong presumption that, my lord, that I have made a second default, and my lord, my application filed for condonation of the delay and extension of time to file my for the deposit, my lord, had been rejected. And finally, my lord, the learned judge was of the opinion that since a right automatically accrues in favor of the landlord once a default is made, my lord, then my defense should be struck off. My lord, may I take you lordship through the impugned order once? My lord, may I place the same, my lord?
yes.
My lord, my lord, from the portion of considered, my lord, I am placing, my lord. Anyway, my lord, entire. Today is fixed for hearing of the application dated such and such under section 17(3) of the West Bengal Premises Tenancy Act of 1956. My lord, this is the old act filed by the plaintiffs.
No, did you comply with the order passed under section 17(2)?
Yes, my lord, may I just briefly tell you facts? My lord,
Because here it has been recorded
Yes.
from February 2022 to June 2022. You have filed an application for extension of time.
My lord, may I just indicate the facts first? My lord, the suit was of 83. From 83 onwards till February 2022. My lord, January 22, sorry. My lord, I have paid continuously. My lord, March 2022 and February 22, my lord, admittedly by me, there was a default. My lord, there was a COVID situation towards the end. Change of staff. My lord, there was a default. My lord, I tendered a consolidated check. My lord will kindly come to page 74. My lord, that was refused. My lord, when that was
You have tendered to the directly to the landlord.
My lord, that was the order of the court. My lord,
That's the order of the
yes,
court.
my lord, initially,
Yes.
my lord.
Then what happened?
My lord, he refused. My lord,
Yes.
he refused on the ground that I will not accept it because the month of February has not been paid. The rent for the month of February has not been paid. Now, my lord, he refuses. My lord, I again tendered the checks. My lord, ultimately, I filed an application under section 151, coming before the court and saying that yes, there has been a default essentially of Feb and March. Refused. My lord, hence I am ready to pay. Kindly extend the time. Allow me to pray.
What happened on that application?
My lord, two orders were passed. First, my lord, it is rejected. Second, on the very same day, my lord, it is allowed, subject to the rights which have accrued to the plaintiff already. Now, my lord, the period was wrongly mentioned. Again, I went up in a section 151 application for modification.
Where is that order passed under section 151?
My lord, the first application's order is at. My lord will kindly give me a moment. My lord, first I would like to show, my lord, before your lordship looks into that, page 74. 74 is the order.
So please show me the order passed on 151.
Yes, my lord, this is the order. My lord,
Page
it's at page
74.
74. Now we have deposited. Check it. ঠিক আছে ঠিক আছে
So did you challenge this order of 17th of August
No,
2022?
my lord, I did not, because I tell your lordship why. Because, my lord, I was permitted to deposit without prejudice to the.
Condition was subject to the rights,
Yes.
preserving the rights which have
Right,
accrued.
that is
That
right.
right is under section 17(3). That has not been disturbed.
My lord,
And by the first portion, your prayer for extension got rejected. If you have accepted that, madam,
my
nothing.
lord, may I? My lord, this right doesn't automatically accrue. My lord, it automatically accrues when there is a second default. This is my first.
When there is
A second default. My lord, this is my first default. My lord, there has been no default before.
second default, I could not understand.
My lord, 17.3 and 17.4 has to be now read together. My lord, if first, my lord, when there is a default period, my lord, I can apply to the court under section 17.1 and say there is a default, my lord, after receiving summons or after entering appearance, telling the court, yes, there is a default, arrears and current month, I will pay. My lord, the court has the liberty to then grant me time. My lord, then I pay. My lord, if there is again a default under 17.4, my lord, I can again apply, provided the default, the second time when I'm making a default, my lord, I'm making a default of 4 months in a period of 12 months. My lord, first of all, there has been no default at all. This is the first time, my lord, I have made a default, admittedly because of the COVID situation. Whatever it is, my lord, there was a default only of 2 months. My lord, I tendered the rent. My lord, that was refused. My lord, belated tendering of rent for 2 months, my lord, is only a technical default and not a default in the real sense. Your lordship is aware, my lord, there is a judgment of the Honorable Supreme Court of BM Khemka, my lord, that has been followed by our High Court Division Bench. My lord, so this is a technical default. Be that as it may, my lord, I have tendered the rent. And my lord, there is no default at all. My lord, why I tell your lordship, while going to the impugned order, will find a reference of an order of 2001, whereby, my lord, I was directed by the learned trial court to pay directly to the advocate on record of the plaintiff. My lord, at that point of time, my lord, there was a change in the advocate on record, because of which I could not make the payment. The court held that my reason for non-deposit was valid. There was a confusion.
If you have not challenged the order dated 17th of August
My lord, you
2022.
don't need to, perhaps, because, my lord, the right is not automatic. My lord, there is no automatic accrual of right. My lord, there has to be a default of more than 4 months. My lord, will kindly look into section 17.341 and one of the judgments, my lord. My lord, may I just hand over? পুরো 17 টা দাও।
56 Act আনিয়েছেন না এখনো আনাননি? ওয়েস্ট বেঙ্গল পুলিশ যে 56 কবে থেকে বললাম আনিয়ে নিন, আনিয়েছেন দিন। Yes.
My lord is looking into section 17, my lord. My lord, 17.1, my lord, where I can pray for time. My lord, 17.3, your lordship will kindly see. 17.2, my lord, that is adjudication when I dispute the quantum of rent and all. My lord, 2A, I did not file for an extension. 3, your lordship will see. If a tenant fails to deposit or pay any amount referred to in subsection 1, 2, within the time specified therein, or within such extended time as may be allowed under 2A, my lord, not applicable in my case, or fails to deposit or pay installment, etc., the court shall order defense against delivery of possession to be struck out and shall proceed with the hearing of the suit. My lord, this shall has now been held to be a directory. It cannot be taken as a mandatory provision.
Layer 87 Supreme Court 1010.
Yes.
Is
So,
that the citation?
yes.
Yes,
So,
next.
now subsection 4. If a tenant makes deposit or payment as required, then no decree will be passed for possession. My lord, my ejectment suit is on the ground of reasonable requirement as well as default. My lord, provided that, my lord will kindly see the provision.
So we'll operate when?
Yes, once if I have already taken a relief.
Whether in the same suit or in the subsequent suit.
My lord, I was under the impression that it was in the same suit.
That is why I'm asking you. 17.4 proviso, same suit or in the subsequent suit. This is the language. After having obtained the relief once in the suit, that means 17.4 relief, if you have obtained, then. So it's this 17.4 relief has to be granted at the time of final decision in the suit. So it's got proviso attracts only in a subsequent.
Very well, my lord, be that as
so,
it may.
Proviso, you
Very
cannot
well.
take the help.
Very well, my lord.
Now, 17.3 shall has been made directory,
yes.
no dispute, but you are you have violated, you have not challenged that order, rejecting your prayer for extension under 17(2) capital A, subclause A and B.
My lord, my
Madam,
prayer
that's the
was,
difficulty. That is why I'm asking you.
my lord, my application.
I'm aware of those line of decisions when you have said 1956 Act. Yes, I'm aware of that line of decisions. That is why I've asked you, have you challenged that order?
No, my lord, I haven't.
If you have not challenged,
I-
so you are under 17(2)A, A and
My lord,
B
be that as
gone.
it may, my lord, be that as it may, my lord, this today the defense is being struck out under 17(3), my lord, if I leave 4 away also. My lord, 3, my lord, when it shall, my lord, the shall is not mandatory. So, my lord,
When you have paid, that is why, when you have paid for extension, rejected. So can
no,
the court
my lord will kindly see the second part of the order. It is
Madam,
permitted,
what permitted?
subject to the rights.
That is, extension could have been granted. Now it's rejected, madam. You are not trying to understand that.
My lord,
And that is not under challenge. It is res judicata.
my lord,
Please appreciate that.
my lord, may I just try to convince your lordship otherwise? My lord, it is rejected by the first order. My lord, the second order
What?
permits me.
What?
My lord, your
Second
lordship,
order does not permit you.
subject to the rights.
Yes, so rights, subject to the rights, if any accrue. First thing, if you fail to that, that extension right is gone to you.
Yes.
And unless you challenge that, that is barred by res judicata.
However,
So it cannot be it binding between the parties, not challenged, even by the higher forum, it cannot be set aside.
my lord, be
That's
that
the
as it may.
difficulty. Please
My lord,
apply your
yes,
mind.
yes, my lord, I have followed, my lord, I have tried to follow. But my lord, be that as it may, my lord, may I say this, my lord, this shall cannot be dealt as directly. My lord, if your lordship,
I'm not for the moment disputing.
if that is so, if your lordship is with me on that, my lord, that is one of the reasons why the learned trial judge has defeated my.
I can supply the reasons.
No, no, my lord, will kindly not.
I can supply the reasons
My
for
lord,
that. So only, madam, only thing that is troubling me is that I cannot touch the earlier order, which has taken your right of extension. If that right goes, then has to be. Even by May, it cannot be.
my lord, may I
it
say
has
this?
been
It has
said
to be looked at differently, my lord, because this is a 17(3) application that was
Have
151.
you seen the? Have you read the judgment of 87 Supreme Court?
My lord,
Have you
may I
seen
be
the
candid?
subsequent judgment which came up from Patna?
My
After
lord, may I be
1987?
candid, my lord, citation.
After that, for that 1 month's default, Supreme Court did not condone.
My lord, be that as it may, my lord.
That arose from Patna. Here it is a case where it says if you have not approached there, then it could have been done. Now your prayer for extension has been turned down. That's the difficulty. So in a subsequent, I cannot also say because the court is also cannot reopen the earlier order.
I have understood.
That is
No,
the
that part
difficulty.
followed. But my lord, my only thing is, my lord, this 2 orders passed on the same day, first saying no, then saying yes, you can, subject to rights. My lord, my understanding was that no right accrues at all.
Please apply your mind. I am adjourning this.
Very well, I leave to your lordship. But my lord, the difficulty is, my lord, may I say so? My lord, my cross-examination is over. Now, my lord, the final hearing is being held. Well, that will be in the first week of September. Tomorrow? Oh, my lord, tomorrow is the next day.
If your cross-examination is being over, so that is in the light of Modula India.
Well, that I'm not aware of, my lord. I can be very candid.
After striking out the defense, your right to cross-examine, your right to
there and to argue.
your right to cross-examination was on that.
My lord, that I'm
You had a limited right of cross-examination.
my lord, I am not
So if
aware.
that is so, everything gone.
My lord, that is the difficulty, my lord. So, my lord will kindly just.
Now it will be everything to be reopened.
No, my
At
lord,
this stage, it is
before
difficult.
looking into those documents, my lord, I cannot really say for sure. But my lord will kindly give me some time and at least some time so that I can come back and try and persuade your lordship. My lord, I have followed. But my lord, I will try to come up with an answer if I can persuade your lordship. I will try.
Only answer. I cannot say anything more.
Well, I will try.
Please apply your mind. What is to because
Yes, my lord. I have
from
followed.
my observations, if you have got something, you can try your.
Very well, my lord. I will
try to make something.
I will try, my lord.
Ashun. After some argument, the learned
Petitioner, my lawyer friend is for the petition, I am for the opposite party.
Who is for the petition?
I am for the petition.
Yes.
My lord, my
Item number 34.
right to cross-examine the engineer commissioner under order 26 rule 10(2), my lord, has been closed.
How, why?
My lord, may I submit?
Did not appear.
No, my lord, that was not the case.
Mr. Banerjee, he has to be given a.
That was
He has, that's right, because the report automatically forms part of the record. It's an evidence in the suit. Only he has the right to cross-examine.
my lord. I have submitted the objection as well. That was taken into the
Date
record.
of filing, he did not appear. Court gave a chance, adjourned it to the next date. On the next date also did not filed Hazira but did not appear.
No,
Was
you
adjourned.
want some cost?
No, my lord. No, my lord. That was not even the case. Kindly come to the page number 89 once.
Sir, pay some cost.
My lord, kindly come to page number 89 once, my lord. Kindly consider.
Yes, 89.
My lord, on 1st of July 2025, Commissioner submitted the report.
Yes.
Date was fixed on 31st of July 2025.
For acceptance, yes.
For acceptance, WO in the meantime, my lord.
Yes.
In between, my lord, the next order on 22nd of July 2025, my lord. Without serving the put-up petition upon the opposite party, my lord, Commissioner has been asked to come before the court on dock.
Yes, how
No,
that
no.
can be.
On 31st it was taken up.
Then, my lord, I did
It
not
was
know
taken up
about
on
the same, my
31st
lord.
only.
22nd was, how can it be, Mr.
No, it was done on 31st only. The
It was done on
There is the
31st.
order of 31st of July.
I have challenged, my lord, on
number
31st.
70. It was taken up on the date fixed only.
It was taken up
Filed
the
the
date.
put-up.
On one occasion, he did not appear.
Two occasions.
Second, that
No.
July, that was not a date.
First,
that
no,
was
1st July. 1st July was the date.
First
1st
July
July he
was
did not
the
appear.
date.
1st July.
No.
Kindly see 1st July, page 89.
1st July, today is fixed for commissioner's report. On
Yes,
that
report,
date,
25
commissioner filed the report.
Yes.
That should not have been a date fixed for cross-examination.
OP is absent
ma'am.
without steps.
Maybe, but a
So he
date
was
has to be
absent.
fixed.
Yes, date was fixed. The next
So date was fixed on 31st of
31st.
July. So it was on one day he was absent.
On that day again he was absent. No, 31st. First also he was absent. 31st also he was
What
absent.
first?
My lord, in
First
between.
kindly see.
Maybe, but that was not a date fixed for cross-examination.
No.
So for cross-examination, he was absent on one
No,
day.
In between 22nd, my lord, they have submitted, filed the put-up petition without serving the same upon the opposite party. That was not, my lord, a procedure to be followed before the trial court below.
Copy was served.
No, my lord, never been
Would not have
served.
allowed. Then court would not have allowed.
No, my lord, I can come up with the record.
the APR.
Yes.
Very precarious circumstances, my lord, I have taken instruction. My lord, this man is, my lord, is going through a severe heart disease, my lord. So, my lord, one of the reasons is this. Second issue is, my lord, he is involved in certain government projects. Now, my lord, his money is stuck there. But, my lord, I had said that there is a decree of the court, my lord, you have not challenged, you have to pay. So, my lord, he has agreed to pay, my lord, 4 lakhs by a month's time. He will arrange 4 lakhs by a month's time. And thereafter,
Month's time.
but it will, my lord, your lordship knows in one day, my lord, nobody can arrange 4 lakhs because he's in paucity of funds, my lord. This is, my lord,
How
otherwise
much you have paid?
10,20,000.
10,20,000 he has paid. Ashun. kept it
Well,
on
let,
22nd.
then well, let me file an affidavit of compliance before this court showing that I have tendered the money. Let that direction be
I've
there.
kept it as to be mentioned. Do that. I am not passing any formal orders. Acha, করে দিন, on that date, to be mentioned on that.
For the respondent number 1 and 2.
Lord, I am for the petitioner, my lord.
While the divisional application become infructuous as
Become infructuous. Why?
today morning possession is handed over to the decree holder.
Person has been handed over.
Today morning.
Yes, my lord. We have came to
Today
know,
morning.
Today morning.
we have came to know, but my lord, the one single point, my lord, the appeal is pending.
Appeal is pending.
Appeal is pending. We paid for a stay of the
So
execution.
now this execution has been, they have taken possession.
Just
Appeal will be decided. Appeal will be decided.
appeal may be decided, but my lord, we have been ousted. That is the, we have been ousted, my lord. That is the predicament, only predicament, my lord. My lord, my application was dismissed. The stay application, which I have filed before the execution court, because the appeal was pending. That stay order have been dismissed, and we have come for the.
What is the decree for? What is the
Yes.
decree for?
Decree for the
Recovery of possession.
recovery of possession, my lord. In terms of the counter claim filed by the defendant in the suit.
Yes.
My lord, come to kindly come to page number 48 of the revisional application. The counterclaim has been decreed. We have been staying there for last 65 years.
All right. So appeal is pending.
Appeal is pending.
Disposed of. So you get the appeal disposed of. Can get back
It will
possession.
be decided.
144 is there.
Yes, my lord. No, my lord. I have been ousted. That is my predicament. Yes. Nothing to say, my lord, further.
This application under Article 227 of the Constitution.
For the opposite party.
Opposite party?
Yes.
Yes, Mr. Rai.
Rai is there.
Yes.
Two things, my lord. Whether the appellate court can add a party who is not a party in the suit and impose the order of injunction.
What is the appeal?
Yes.
For?
Refusing to grant ad interim order of injunction. The colleague, what is the suit for? The plaintiff case made out that the cause of action arose.
You are the defendant.
I am the defendant, added as party, now in the suit also. Not a party.
Not a party.
In the appeal court, I have been made party, so must.
My lord,
And order 1 rule 10 was moved and that has been allowed.
Yes.
Suit was filed in the year 2025.
What is the suit for?
Declaration of tenancy right, recovery of possession on the allegation that the tenant has been
Tenancy right because allegation that
dispossessed.
Dispossessed, yes.
In the 2025. Filed a suit by impleading some persons to be the landlord, and he filed a suit for declaration. Trial court refused to grant additive order of injunction. Appeal preferred. Appeal granted additive order of injunction. Subsequently, an application was filed.
Appeal court granted an order, additive order of injunction.
There, an application has been filed under Order 1, Rule 10, saying that the property has already been transferred. On that score, they are made party. Without opportunity of hearing, be as it may, that is one of the points which I will argue. Now, my lord, and that injunction order was directed to be extended to these persons. Two things. This is an appeal under Order 43 Rule 1. Whether, my lord, Order 43 Rule 20 will apply or not. Because it is not an appeal under 96 or so 107 will not apply. It will be restricted to the parties to the suit. It is not a regular appeal. Now, while Kali approval to this, while Kali consider the plaint itself. Kali turn to page 240.
So you are the added party. So you are aggrieved by the order of injunction. Extended against you.
And also the order of injunction, because the property was transferred in the year 2013 from their document and satisfy your lordship. Suit was filed in the year 2025 without impleading being party. And my vendor was made party and order of injunction has been obtained in a misappeal. That is the ballot one. Can you turn to?
Please give me a
the
minute.
Plaint. Page 240.
Please give me a minute.
দেখতে 240 তো প্লেন্ট 240 এখানে দেখো পার্টি কোড এটা করিস না যে অরিজিনাল থেকে এই ছিল থেকে পার্টি কোথায় Page 252.
No, please give me a minute.
It is at page 240.
Yes, so it was filed against Nantu Nag and others. Who is Partho Chauhan? This is the proforma defendant. You are not Partho Chauhan.
No. I am not party.
All right.
Now, he is claiming to be a tenant under this person, Nags.
All right.
On the basis of such pleadings, my lord, can you turn to paragraph 27?
The allegation.
252.
No, this is for recovery of possession.
Yes.
Show me the allegation of dispossession.
252, paragraph 27. I got it. Date of disposition 16 December 2024.
Yes.
Now, my lord, can you turn to the prayer? Page 258. And 260 is the schedule.
260 is the schedule.
400 square feet.
Yes. Yes.
Now, my lord, can you turn to the application for order, for injunction,
Application?
for injunction,
Yes.
page 264, paragraph 3 and 4.
Averments will be the same.
Only two things. I have not drawing losses over the other.
Paragraph?
3 and 4.
Yes.
Tenancy under whom?
Yes.
The defendants. Now, if your lordship can turn to the order passed by the London trial court while refusing to grant identity order of injunction. ওটা কোথায় বলতে হবে? Identity order of injunction. The 457. Kindly turn to page 457.
This is the trial court's refusal.
Refusal.
Yes.
Now, kindly takes up the volume. একটাই আছে না দুটো ভলিউম তো না?
Where is the order passed by the appellate court?
Yes. Kindly turn to page 28.
28 of the order impugned. No, order impugned is after your addition. No.
No, that is
Page
17 March.
28. Only 28.
Yes. देखिए. Order 17th March.
Two orders have been challenged, one of 17th of March, which is the order 1 rule 10. The other one is of 27th of March.
27th of March.
Page. Is a certified copy? No.
The certified copy.
Certificate copy is
Certified.
annex.
It's after the third volume.
I've been served only 2 volumes.
17th March 2025.
Yes, 17th March is the order 1 rule 10.
Along with the injunction extension. The appellants filed application for extension of interim order.
No, 17th of March is order 1 rule 10.
Before that.
Interim order of injunction.
From the top. Extension of the injunction, my lord. 17th March 2025.
Yes. Yes.
The appellants filed application extension of interim order of injunction. I will file an application under order 1 rule 10(2) of the course of 2210. Pause there for a moment. So there is 2 applications are coming. One is this order 22 rule 10 for devolution of interest during pendency of the suit. Another is order 1 rule 10.
It's captioned as read with, not 2 applications.
No. Either it should be order 22 rule 10 that during pendency of the suit it is transferred.
Now, Mr. Rai, applications are filed mentioning all the sections. Order 1 rule 10.
Then my lord, order 1 rule 10.
Section 151, whichever way it goes.
So I am
Maybe
proceeding.
under in some cases order 6 rule 17 also.
So I am
Amending
proceeding.
the cost title.
So I am proceeding as if it is an application under order 1 rule 10 or addition of party.
Yes.
Persons mentioned in the schedule as party responded on the ground. The suit property has been transferred to the person mentioned in the schedule of the present petition. Peruse the copies of the deed of conveyance. It appears the respondent transfer the suit property to the person mentioned in the schedule of the present petition. Presence of the purchaser of the suit property is necessary for adjudication. Order 1 rule 10 allowed. I got it.
Yes.
And after that, the consequential orders are also been challenged. So this is an injunction which has also been directed to be extended. Yes. Now pause here for a moment and Malak, can you turn to the documents which was there, deeds. Kindly turn to page 32.
No, Mr. Rai, please show me the order of injunction initial passed by the
Appellate court.
Yes.
Before that. That your lordship will find at the first order number 2 dated 19th February 2025. Subject to correction.
It's part of the certified copy.
Part of the certified copy. Order number 2.
Yes.
So this was the order passed. Be as it may, rightly, wrongly, injunction has been granted by restraining the original owner from changing the major character of the tenanted portion of the appellant plaintiff in the suit property and not creating any additional alteration construction thereon from getting a third party interest. Now, my lord, apropos to this, can we turn to page 32?
What is 32?
The deed.
No, show
On
me
the
their-
basis,
I will come to that. Please show me their application under order 1 rule 10 or order 22 rule 10 in whatever way you say.
that is not with us.
That is
Not with us because we did appear, it is filed and allowed. That I'll come after. Before that, can you turn to page 32?
page 32. Yes.
The first deed of conveyance.
This is by virtue of which you became the owner.
Yes. One by one. And can you turn to the date?
1st August 2013. Yes.
Next is, my lord, can you turn to page 51?
51. It's another deed.
Yes.
Why?
This is
By
1000
part.
by party as a trust.
No, what is this suit property? By which deed of
This is 400 square feet is the, he is in occupation of 400 square feet. Total area comprises of 1900 square feet. And 3 or 4 parts it has been transferred by.
All right. So what is the last deed?
Last deed is
So one is of 2013, another is of
21. Subject to correction, my lord, page 90.
90.
Yes. Probably this is the last one.
2021. Yes.
90. Page 90?
Yes, 2021.
Yes. Then, my lord, how cause of action arose for getting an order of injunction against a person who was not been made party? It is not a lease pendants transfer. The cause of action has been mentioned as on the basis of the fact that the transfer has been effected during the pendency of the suit. On the contrary, for the document itself, while satisfying a lordship, the transfer has been effected prior to filing of the suit. Then, my lord, can you consider on the basis of this cause of action the injunction can be granted or not? It is a public document. This is a registered document in the public domain. My lord knows better than us. So the preemption application also, my lord has passed this judgment. Once it is in the public registered document, it is a public document. Now, my lord, on the basis of the same, how this injunction can be granted on the basis of the cause of action, which is not there. So there is no allegations over this subsequent transferee. They are the owner. They are in possession of the property. Not only that, the parcels are being added without giving any opportunity of hearing. And the learned court below is exercising power under Order 43 Rule 1 for the purpose. He is not exercising power under 107 because this is not a regular appeal on either 96 or 100. My lord will find the judgments are also there. The court cannot, in the appellate court, exercising power under Order 43 Rule 1 cannot exercise the power under Section 107 for adding a party. It should be interested parties between the This is reported in ILR Bombay. Huh? 29. 92. 601. Which? 601. It is the page টা বলে দিই দাদাকে পেজ এখান থেকে পাবো না 598 এই এখান I should be disposed of all the is expressly subject to the condition of the limitation. It must be subject to Order 41 Rule 20 and therefore in the order tenor party added appeal from the suit itself. Yeah, 107.
Not 40.
Huh? একটু তোর যন্ত্রটা জজকে তুলে দিতে পারবি? তোর যন্ত্রটা একটু জজকে তুলে দিবি তো? ওই 25 এর জাজমেন্ট ইন্ডিয়া রাইট অফ ইন্ডিপেন্ডেন্ট অ্যাপিল। তুই কর না, কার টেক ইউর টাইম। ঠিক আছে, রাখ রাখ রাখ।
Yes.
Last portion of the order, my lord, this is a, and subsequently, my lord, order 43 rule 1 is the right to prefer an independent appeal or not. देखिए,
Yes.
if your lordship may kindly enough to take a 107 of the court of civil procedure once. Subject to conditions and limitation as may be prescribed by an appellate court shall have power to determine the case finally, to remand to final the issue. Take addition, subject to the aforesaid, the appellate court shall have the same powers and shall perform as merely as may be the same duties as conferred and imposed by the court of courts of original jurisdiction as to the suit instituted therein. So it is the court is exercising, the appellate court exercising the original power of the civil court. Considering the same manner, can you consider the language used under section 96 and 100?
Yes. Yes.
So, every court degree passed by the any court exercising original jurisdiction of the court authorized to hear the appeals from the decision of the court, any appeal lie from the original degree shall from the degree passed by the court has consent of the parties, no appeal shall lie except on question of law. I'm skipping over the same portion. So these are 96 and 100.
Yes, 96 and 100 says appeals from original decree.
Degree.
From
That is
appellate.
my lord. This now, my lord, whether 43, what the language of 43 or of 43.
Yes.
Now, my lord, this is restricted to section 104. The power exercising 104 of the Code of Civil Procedure. 104, if your lordship considers 104 once, my lord, for the sake of repetition, my lord.
So according to you, in an appeal under section order 43,
107 cannot be exercised.
Order 41, rule 20 cannot be
exercised.
Mr. Order 43, rule 2.
Order 43, rule 2. 41 will apply so far as maybe appeals from orders. So far as maybe,
So rules of order 41, all rules will apply to order 40.
but it is not an independent right to prepare an appeal. That is the Supreme Court says. I'll come to the 2025. This order 43 rule 1 does not give any independent right to prepare an appeal.
No, that is, no.
So therefore,
43 rule 2 says all provisions. all
the
rules of-
procedural part will apply.
Yes.
Procedural part will apply. 107, my lord, is a part which retains the court, appellate court, to exercise the power.
Procedural part gives right to add a party. It's the procedural part, not the substantive part.
Yes, substantive.
Procedural part gives a right to apply for addition of a party. So that's the procedure. Procedures will apply.
That is what.
According to you, it's not a substantive. So the why?
To what extent it will
Yes,
that
while
is
deciding an appeal under order 43, the court cannot decide the case finally. That's a different thing altogether.
because unless until the parties addition of party means my lord, if you logically consider. Order on rule 10, if you logically consider, the court suit at the time a proper party or necessary party, or court can strike out the parties also. So therefore, my lord, the order 43 rule 1, when somebody is added as a party, the court has to come to finding that he is a necessary party for the proper, then the merit of the suit and the issue to be decided.
Yes, that's the logic.
Non-gender necessary party. Well, if you logically consider non-gender necessary parties. And non-gender parties, there is distinction between the same. So today, the appellate court exercises the power of the original court regarding addition of a party to make the order of injunction valid. Specifically when against whom the injunction was passed, there is no cause of action to file a suit against them. Am I clear to your lordship? So this independent right.
According to you, no cause of action has been pleaded against these added parties in the suit. So whether on the basis of this addition, this injunction can be extended.
He was in opportunity. What are the deeds and how it has been placed? I do not know. I have been made party. Suit was not filed against me, but I had to suffer an order of injunction.
Yes.
So, as of this day, my lord, if the suit is degreed, keeping aside, why is that the degree is executable against me? As on this day also, I am not party. And the appellate court, it percolates down, my lord knows better than us, my lord. In the higher forum, if something is added, my lord, it percolates down.
Mr. Rai, that's on substitution.
Same.
So can it be?
Court has directed for addition of party. Appellate court directed for addition of party. Whether this addition of party can be challenged or can be taken a different view by the subordinate court.
So according to you, there is no necessity for filing an independent application in the suit. Automatically, you are added as a defendant in the suit.
Where is the cause of action against me? I am the owner in 2013. Suit was filed in 2025 on the basis of the allegation that the Austrian landlord disposes them from the property in question. So where is the cause of action against me to be pleaded as a party? So if I have been added as a party, there is no cause of action pleaded. The suit itself is brought under Order Rule 11. So if the ultimate fate of the suit is, but the scenario is, but dismissal of the suit, whether an interlocutory order of injunction can be passed at all or not, in the aid of final relief. We are not there, still I am not there to get my addition without giving opportunity of hearing. Nothing.
Addition, Mr. Rai, is it has
It is
to
not
be
of its own. I could have understood the court of his own came to the finding, yes, you are necessary party, so I am adding those as a party. My lord knows section 24 of the Code of Civil Procedure. Two aspects. When the court transfers a suit on the basis of administrative power, you need not to serve notice. But when upon application you want to transfer, has to be served. Here also, my lord, order on rule 10, if the court is of the opinion is these are the persons required to be made party, court need not to serve notice about the. But when you are acting on the basis of an application, that is bound and duty to serve notice. Because I have some objection. The persons who are added, God knows those are alive or not. Because I know one is dead.
Yes, any Supreme Court judgment which you are trying.
Independent right to prepare an appeal. Order 43 rule 1. My lord, I have my copy and I hand over this Jonto to your lordship.
That copy you take that.
2025 SCC online, Supreme Court 930.
Give me that copy.
Eight.
You take that. Yes.
Take this is my copy for my last paragraph 15. Last line. I'm only placing only one line. And what is the issue? The party is not a party, is a compromise. Paragraph 15, last line. Order 43 rule 1A. My lord, got it?
Order 43 rule 1A, yes.
Does not create an independent appeal at all. I'm reading this line. If you have no independent character of the appeal under Order 43 rule 1, then you cannot enlarge the scope of the appeal by adding some other person who has not been made party in the suit. And the issue, my lord, will find?
This is Mr. Rai, it's a different thing. This one compromise. Order
that is why on the compromise.
43 rule 1A.
Yes.
Is the right to order 43 rule 1A and order 43 rule 1 is a different thing altogether.
Yes.
So order 43 rule 1A deals with compromise, right to challenge or compromise.
Precisely, that is why, my lord, the independent right to prefer an appeal under Order 43. Whether any person aggrieved can challenge that appeal without being made party in the suit.
Order 43 rule 1 is a different thing, Mr. Rai. It's a different thing altogether. It's on compromise.
Why I am saying, well, who is not a party to that proceedings? That is why.
Thing, because this judgment may not be of.
So whether, my lord, why I am citing this in right to prefer an independent appeal? A person aggrieved, my lord, will find the language used.
An aggrieved party, Mr. Rai, has a right to appeal under Order 43 rule 1. Has the right.
Subject to question, my lord, even logically consider language used under Order 43 rule 1. Language used.
Yes.
No person aggrieved, right to prefer an appeal under Order 43 rule 1 comes. My lord, your lordship kindly consider.
It's an appeal under section 104.
104. My lord, can you consider 104? And Order 41 rule 20.
There's an appeal shall lie. So it's an independent right of appeal. Why do you say it's not?
Because the person aggrieved in other, if you logically leave to prefer an appeal, if you logically consider that is the appeal subject to 107 can be exercised. Under Order 43, my lord, the 107 cannot be exercised.
No, 107 may not be exercised.
Then, my lord, if that be so, then, my lord, you are adding a person in the appeal is not a party to the suit.
That I appreciate. But what you are saying is not an independent right.
Independent right in that sense. If today, my lord, can you consider?
So according to you, a third party do not have a right. May not have a right to pray for leave to prefer an appeal or in other ways. That's
47. Well, can you consider 47, 21, 97? The distinction has been made. Interstate parties. Then, my lord, third party can also file an application under section 47. To what extent, my lord knows better than us. The same is available to a person under Order 97. And that is why it is directed to consider to be independent character of independent suit. Similarly, here you are adding me as a party against whom there are no cause of action has been pleaded. It is not a case during, I am a lease pendants transferee. I'll be bound by the decree. Then whether this addition can be at all be maintainable, and that too by extending the order of injunction. Apart from that, 400 square feet, cause of action pleaded 24, when it appears the transfer has been effected 5 years back. That is to ex parte additive order of injunction, refusal to grant ex parte additive.
Anything more?
This is
Yes. Yes.
My lord,
Where is your application under order 1 rule 10?
is right. Order 1 rule 10 application. No, no.
Yes. Yes.
My lord, I had to get that.
All right. Let them find out. You can proceed.
My lord, first thing first, my lord, I was a tenant. There's statements that in the application here, this is my application. Are copies?
yes.
Have an extra copy.
No, I
Because
don't
please
think
give it to them.
I don't think that, then my lord, I have to come back. Even I have not gone through these applications, my lord, I'm sorry.
আপনি অর্ডার দেবেন?
Yes. Yes.
My lord, first thing first, my lord, I have been from time to time issued rent receipts, and thereafter I've gone to rent control, and the matter is before rent control. 286 is where the rent receipts are given. And my lord,
when did you last pay rent? And where?
Before the rent controller. My lord, that,
When? What is the last rent receipt?
what is the last rent receipt? Now, this has been from their documents, I find page 326. In 2005.
2005.
Yeah, onwards, I find
2005 onwards, you are paying
to rent control.
to the
This
rent
is the
control
last
up to date.
Yes, yes.
In the name of
In the name of the original owners of the land. Yes.
the erstwhile owners.
Yes. Well, I have not been given any letter of atonement. I had no knowledge of this. At this stage, my lord, yes, I had come to know of the transfer. And therefore, we had made this application under Order 1, Rule 10. That has been allowed. Well, they have come on the basis of that order, the 17th March order. In the meantime, I must tell before my lord that the advocate over there has made an application before the trial of the amendment, and that has been allowed. Amendment, I am told, is being carried out, but has not.
Amendment of
the plaint to add them as parties.
No, amendment or addition?
Addition of the parties.
Not amendment.
Yes. Addition.
Not amendment.
No. Addition of the parties in the suit proceeding. That has been allowed and is being carried out. Now, they have come on basis of that. And my lord, if Order 1, Rule 10, I don't succeed, then the 27th March order is, of course, but my lord kindly appreciates this, that this is a property where I am a tenant, a bona fide tenant, and I knew the erstwhile owners. I had made this suit before against them, and subsequently I came to know of these people that they are necessary parties to adjudicate my suit, and therefore they have been added as parties. Now, on that basis,
what is the cause of action against the subsequently added parties? Show me.
Well, I am a continuing tenant.
show me from the pleadings. That is a submission from the bar. Show me your cause of action pleaded against the subsequent purchasers. For
As
the
in the order
purpose
one
of
rule
getting
taken.
an order of injunction, you have to make out a strong
I
prior
agree.
case, balance of convenience, inconvenience, irreparable loss and injury. Show me that those three tests are satisfied in this case.
But the application upon addition of the parties is as page 138, my lord.
Yes.
It is 39 1 and 2 subject to correction, my lord.
Yes, yes. No other applications.
So this is one order 39 rule 1 and 2.
Yes.
In the miscellaneous appeal.
Yes, the order one rule 10 is not on record.
Order 1 rule 10 has
No,
not
I
been
don't- I
annexed. So in this order
I have to-
39, in this order 39 rule 1 and 2, show me allegation, the cause of action against the subsequently added parties.
But, perhaps, my lord, paragraph 38,
Paragraph 38 at page
148, my lord. Continuing paragraph.
Yes, yes.
In the meantime, my lord.
In the meantime,
Yes.
yes. Different numbers 5 to 8. How, when they have been added? Different numbers
No,
5 to 8.
That is correct. Because they're not
Then
here added.
how can you implement them as different numbers 5 to 8 in the appeal?
I
When have you filed this application? Order 39 rule 1 and 2?
When was this filed? The qualifying grounds. On 27 or 17.
This is ad interim.
Yes. On 27th.
This is ad interim.
March. Yes.
Sir, ad interim in a miscellaneous appeal arising out of a refusal to pass an ad interim order of injunction, how can you incorporate new facts?
My lord, that order was.
Scope is very limited.
I agree, my lord. But
So
that
scope
order.
is very limited when you are preferring an appeal against an ad interim order of refusal. So you have to restrict yourself to the case made out in the plain. You cannot make out a new case.
My lord, the ad interim order refused has been appealed, has been come. We have
Sir,
come
what is the
against
scope
that.
of that appeal?
And that order was 19th of February.
Sir, what is the scope of that appeal? Scope of that appeal is very limited.
I agree with that.
So you cannot enlarge the scope of the appeal than the plaint. So if that cannot be enlarged, where is the scope of adding new parties? Where is the scope of passing an order of injunction against third parties who are not parties in the suit?
Well, they have been allowed to be under in that order one
Sir,
order.
you cannot enlarge that because
only after
what the appellate court from an appeal refusal to pass an order of injunction, only the plaint, nothing more. So in the plaint, there is no allegation against these defendants.
I agree, my lord, because they were not parties.
So how can
the
you,
amendments have not been brought?
Yes, so you cannot enlarge the scope of the appeal. How can you enlarge the scope of the appeal?
Well, kindly see
that is
this.
first. Second is the now you cannot say a new fact in the appeal. Only the plaint averment. So in the plaint, there is no allegation against them. So it's a fifth case for rejection of plaint under Order 7 Rule 11. Non-disclosure of cause of action. against this added party. You are saying they have been added without any cause of action, fit case for rejection of claim. If your submission is that they have been added with no corresponding
Order 1 bulletin has
amendment.
been allowed. We have
Yes.
gone before the trial
So,
court. That's
as
my
it is,
instruction.
I accept your submission. So plaintiff is liable to be rejected under order 7 to 11, failure to disclose cause of action against the added defendants.
For that, an
So it
order
can be
was
suo motu. Who can be suo motu. Does not require an application even.
Well, I
Does
might
not
have to,
require an application even.
I agree. I have to seek necessary.
Seek. So now the plaintiff has to be rejected.
Well, may I come back then on that point?
What coming back?
Well,
on what? This order has to be stayed. Right now, this order has to be stayed.
Well,
You come
heavily
back.
prejudice, they're
No.
going on with the constructions. Heavily
That
prejudice.
means, my lord, the position the
19th
construction
of
has
February,
started.
You have been dispossessed.
Yes.
So you have been dispossessed.
Yes, I agree to that.
Where is the scope of passing an order? Your remedy lies in recovery of possession. Where
Section
the
18
scope
is
of-
there. Section 11C is there under the new Act, 97 Act, old Act 18. If he is a bona fide tenant,
Your
he is
case
entitled.
is that now is the case, rightly or wrongly, you have been dispossessed.
Yes.
In violation of an order of injunction or prior to that.
Prior to that.
So if it is prior to that, then it's also not in violation of an order of injunction. So your remedy lies in recovery of possession.
Hence
Not
the
straight
suit.
for.
I know.
So,
Hence the suit.
yes.
But yes,
So in
they
a
are not a
suit
party
for
to that
recovery
because
of
we didn't have
possession,
the knowledge.
where is the case for this construction? Your remedy is if you succeed in proving your tenancy right, you will be entitled to relief under. Yes, Mr. Rai, what is that provision? Relief, restoration of possession?
Order 18, my lord, your lordship is
No. In the premises.
144. Restoration of position.
That is tenant, if he is unlawfully dispossessed, he is entitled to that tenancy. Restoration of tenancy, section under the premises.
36, my lord. My lord is Premises Act.
Premises tenancy act. So you are entitled to a restoration of tenancy.
That is
That relief you have. You have also not prayed for that.
Apart from that, the
It
construction
has yet to be amended to that extent.
Sir, it had to be, when you have said you have been dispossessed, it has been demolished. Your suit has to be framed in that line. Because tenancy you have been dispossessed. So your relief ought to have been for restoration of tenancy. Not for simpliciter suit for restoration of possession.
Ad interim order, I am told, is been passed on the basis of this judgment. May I?
On the basis of
this judgment that was cited.
Kindly
cease. In the relevant paragraphs are 35, 36, and 37.
Nothing was relied upon in the impugned order while extending.
I can see that. I can see that.
While extending, nothing was relied upon.
But this
Yes,
was
even
relied
if you
upon by
say
us.
yes, show me which paragraph you are relying
Paragraph
upon.
35, 36, and 37. New developments. Now the problem is, these are people who have bought the land, but they are developers who will construct and go sell and go out. Unless I have got an order 1 rule 10 order, I'm carrying out the necessary incorporations in the plaint. But some protections are required because otherwise severe prejudice will be caused.
So that was not a case of tenancy. The purchase was there, ownership was claimed. Here it's a case of tenancy. You have admitted that possession has been taken. Your property tenancy has been demolished. That's your admission in the plaint. If that is demolished,
Yes.
so where is the question of granting an injunction protecting your possession now?
At least from creating any third party interest.
That is now the question is without.
Because they are developers, they will sell and go.
Yes, I am also ready. In view of the latest Supreme Court judgment, near about 56 crores.
You deposit that. Injunction you will get. Deposit that. There are line of decisions.
I am doing this, my lord, honestly.
Because, or if you are entitled to, you can
How
get.
can they come back with 56 crores?
Yes, restoration of tenancy. Because you are stalling. If you are stalling a project, if your suit is dismissed, then you will have to pay that. That will be kept.
Yes.
That will be forfeited. And in case you win, you will get that
I'll not touch.
injunction, or you get a restoration of your tenancy if you succeed. That's the difficulty.
I mean,
or you get them included in the suit, obtain an order of injunction in their presence. That is the other way around.
your lordship is suggesting that once they are implemented in the
Has to be, because in the
an
appeal, how can
application,
it be?
fresh application will move.
I'm not suggesting anything. I'm saying in the appeal, how can it be? Since you are saying in the suit, nobody knows what will happen in the suit. Yes, you want to come back for what?
Well, I actually have to. I was briefed only yesterday, so I couldn't go through everything. I had to see if anything is there to come back with. I understand and appreciate my lord's views. If I could get a little time, that's all.
Because injunction extension in this way cannot be done. Even assuming everything, one line extension has to be a reasoned order. Has to be a reasoned order. Has to be a reasoned order.
Well, may I, for abundant counsel, come back? But
Stay for stay of the operation.
Order has to be stayed.
Well, if the stay takes place, everything goes.
I cannot be.
That cannot be, because prima facie, I will record my findings on this, because prima facie cannot be. Ashun. This application under Article 227 of the Constitution of India is at the instance of
My lord, one thing, there are two orders which have been impugned. One is the Order 1 Rule 10 and the other is the injunction order of 27th of March.
practically the order of injunction is affecting them.
Yes.
Order of injunction extension
consequence.
mechanical. So that's
Consequence.
affecting them.
I can understand
That is
why
affecting
they're here.
That is affecting them. Is at the instance of added respondents. Mr. Rai, please hear this. Is at the instance of the added
Other defendants have not been made to a party in this 227 application.
Yes, Mr. Rai, you have not made the others as parties.
Plaintiffs, defendants. Kindly see the cost
Other
title.
defendants who have not made parties.
Kindly see the cost title in the
I'll add the party, one of them, the pro forma.
240. No, they're not here. They're not here.
Leave add the parties.
On the prayer of the
They're the pro forma opposite parties.
on the prayer of the learned advocate for the petitioner, leave is granted to the learned advocate on record of the petitioner to amend the cost title of the civil revision application by adding the left out parties, here and now. Paragraph. This application under Article 227 of the Constitution of India is at the instance of the added respondents in miscellaneous appeal number 36 of 2025 and is directed against an order dated March 17, 2025 passed by the learned District Judge 24 Pogna South at Alipur. First up, the opposite party numbers, your opposite party numbers 1 and 2.
Yes.
The opposite party numbers 1 and 2 filed a suit for declaration of tenancy right. Where is the plain page?
240. না না আমার এখানে লেখা আছে
Praying for declaration of tenancy right under the pro forma opposite parties herein, and for restoration of possession on recovery of possession from the pro forma opposite parties herein in respect of the suit property, and for mandatory injunction
page 258, my lord.
Directing the pro forma opposite parties herein to execute a tenancy agreement Yes, call the next matter. With the service. Yes.
Item number 37. My lord, I am for the vehicle opposite party landlord, my lord.
Yes.
Defendant is a petitioner before your lordship.
Yes.
Suit for eviction, my lord. My defense has been struck out. My lord,
Nothing left, Mr. Halder. The way you have started, it's nothing is left.
after closure of evidence of PW1, my lord, the suit was posted in the argument stage. I took out an application, my lord, for recalling of the said order and for, my lord, leading evidence.
What evidence you will lead? What evidence you will lead? After 7-3 striking out.
If you also kindly have a look at, my lord, this judgment, my lord. Paragraph 3 onwards, my lord.
Paragraph
3 onwards.
Yes. What you are trying to say?
Since my written statement is already there, my lord, I should be permitted, my lord,
To be hard on merits. You have a right to argue. What does it say? You can lead evidence. Where is modular India, Mr. Halder?
My lord. And another judgment, my lord, of this honorable court division bench, my lord. Kindly see, my lord. Also, lordship's judgment. My lord, kindly see. Paragraph 24, my lord. Modular.
38, my lord, I am appealing for the petitioner, my lord.
Yes,
I am praying for expeditious disposal of a proceeding, my lord. It's a partition should, my lord.
this application under Article 227 of the Constitution of India is at the instance of the plaintiff, praying for a direction upon the learned civil judge, senior division, first court at Barasat, to dispose of title suit number 627 of 2020. Call the next matter.
39, my lord. 39.
In item number 39, my lord, we
Yes.
have lost a caveat and the caveator. However, we have not been served with a
Why
copy.
have you not served?
But it's a just motion
Yeah.
stage, my lord. Just file it and appear before you.
My lord, my lord, you can serve us a copy.
Order 22, Rule 10 allowed.
Order 22 Rule 10 was allowed by treating it as Order 22 Rule 3. My lord, it's a perspective, my lord. Prior to, it is a second order. The first order was set aside by this honorable court. My lord, kindly come to page 48. Page 48, my lord. The perspective of the case is, my lord, like a.
Where is the application?
My lord.
Where is the application under Order 22, Rule
Yes,
10?
yes, my lord. Page 27, my lord. On the strength of an impugned deed, which is under challenge before the same court in title suit number 346, the two sisters of the defendant, after death of their father, who is the father of the defendant also.
So this is an application under Order 22, Rule 10.
My lord.
So that was allowed.
That was allowed.
So it's an appellable order under Order 43. Do you have a copy of the Civil Procedure Code with you, sir? Please kindly come to Order 43, Rule 1L. Either way, allowing rejection, it's an appellable order. Please check up Order 43, Rule 1L.
Order 43, Rule 1.
L, subclause L. This is the list of appellable orders. You have not found out? এই বইটা দিন, দেখিয়ে দিন এই এলটা, এখানে এল রয়েছে, দেখিয়ে দিন। এল ডান দিকের পাতায়। You have got? Order for,
I have very limited knowledge, my lord.
please see Order 43, Rule 1L, L on the right hand page. Allowing rejection, both way appellable. Ashun, din. By the order impugned, the application
Lordship.
Petitioner husband filed a application 13-1-1A before the Honorable ADJ First Court at Howrah, Lordship. The suit was filed 17th May 2023, Lordship. And the next date was is fixed 4th September 2025 for peremptory hearing, Lordship.
Yes, what do you want?
I'm praying before your Lordship to kindly direct them to expedite the matter expeditiously disposal within 3 months, if your Lordship.
Within 3 months?
Your Lordship.
You have conducted any trial of a matrimonial suit?
No, your
Have you conducted any trial of a matrimonial suit? That is why you are saying 3 months.
Lordship, on the earlier occasion, we have got the change brief, the code below, Lordship.
Reconciliation has taken place.
Yes, your Lordship. Yes.
Reconciliation failed.
Yes, your Lordship.
Issues framed.
Issue frame, Lordship. On 25th November 20.
Any application for alimony penalty
No.
filed?
No.
Till now not filed. This application under Article 220. You are the husband.
I'm for the husband.
This application.
That I'm praying for that I'm praying for a direction for expeditious disposal of a case under Section 8, read with Section 12 of the Guardian and Wards Act, my lord, filed by the opposite party, who is my husband, that is the father of the child. My lord, issues had been framed on 5th of February 2024, and thereafter the opposite party husband has filed an amendment petition under Order 16, Rule 17, read with Section.
This application under Article 227 of the Constitution of India is at the instance of the, who are you?
I'm the wife, that is the mother of the child.
So an application for expeditious disposal, but my lord, this is the second round. My lord, on earlier occasion, my lord, kindly comes to page 29 once. My lord, the petitioner has approached the RERA authorities for disposal of its application. Now, my lord, the last date got given on 23rd of July 2024. We preferred an application for expeditious disposal. My lord was pleased to grant. My lord, kindly look into para 5. Then, my lord, the next page, page 30. My lord, 4 months. My lord, we communicated that order. My lord, the client himself, the advocate on record. Thereafter, still date, my lord, the not a date even is being provided for the next hearing, my lord. My lord, subject to correction, what I submit.
Yes.
My lord, let me make serve a copy upon them. Let them come down, my lord. Let them explain, my lord, that in how many days they could dispose of this application.
Who will come?
You know, the RERA authorities. I'll serve on all the parties, but let the RERA authorities appear before my lord. Because unless my lord, they appear and they conduct the hearing, after informing us, passing another order of execution will be a futile exercise, my lord.
When have you communicated this order?
My lord, the first communication on 7th of February, my lord, kindly comes to
Where?
Page 31. Page 31, my lord, the first communication. Thereafter, my lord, the track reports.
No, why through speed post? Why are you not appearing in person?
No, we are appearing, my lord. But
this was sent by speed post.
Yes, my lord.
Please appear physically before the authority and submit
My
this.
lord, we had gone to hand over the order. They are saying what filing speed post to us. We will not accept any order copies. We will not accept.
Where have you stated that in this civil division
that
application?
statement is not, but the delivery,
Please,
the delivery
I'll give
report.
you liberty. Please serve. Please file it physically. The learned advocate appearing for the petitioner. Now this this application under Why, sir?
My senior is engaged for court number 34,
You are here. This
but
start.
I'm not aware about this case.
On the prayer of the learned advocate for the petition at the hearing of the civil division.
Number 44. And my application, my lord. By the impugned order, an application under order 1 rule 10 has been allowed, by which the opposite party numbers 4 and 5 has been added to an eviction suit. These two people, my lord, are successors in interest in respect of a partnership of a partnership firm known as Monilal and Company. They tried to declare themselves as tenants in a previous suit which has been dismissed. An appeal therefrom has been dismissed by this honorable court.
Please give me a minute. By the and file an affidavit of service on the next date. Now, what do you
But
want?
only stay of proceedings, my lord. But otherwise these
Your
people,
suit will be stayed. Your suit will be
this is the
stayed.
instruction, my lord, that because
There shall
the
be-
suit.
There shall be an order of stay of all further proceedings in Cattle suit number 1615 of 2022 pending before the learned judge, third bench civil court at Calcutta, till the end of the month of uh, January 2026 or until further orders, whichever is earlier. List this matter under the heading contested application after 12 weeks. Yes. Yes, call the next matter.
45, you say I appear for the petitioner. This an application under order 1 rule 10 has been refused by the
Order 1 rule 10 has been rejected.
refused.
Whom do you want to add? What is the suit for?
Suit for eviction. Well, I want to, there are some irregularity committed by the learned trial court. This application has not been filed by the defendant as well as the plaintiff. This has been filed by the some of the interested co-sharer of the suit land. And these applications kindly come to page 55. They have been implemented. Page 57, paragraph 8.
Yes, who are you?
My lord, I am the defendant in the suit. I have not filed this application. Kindly see
So
this
how
has
are
been
you
appointed.
affected by this?
My
You are
lord,
not
my lord, I have been affected. My lord, only this co-sharer. My lord, I've been
Set up
impacted.
this. You have set up this person.
So kindly allow me the
Application under- Thank you,
liberty
sir.
given to my lord, the trial court to make a fresh application before the trial court. This is
What
my submission.
press application?
My lord, this application has not been implemented, then I have been suffered. This is my only adjudicate for the purpose of adjudication of the issue. My
Nothing,
lord, kindly.
nothing. Eviction suit cannot
My lord,
be,
kindly
scope of the instance suit cannot be expanded. This application,
my lord, kindly only that.
I'm expediting the suit.
No, that is
That is
I
what?
am difficult.
Why?
Well, I am the defendant here, so it is expedited that. I mean,
What is the stage of the suit?
my lord, this is why evidence is going on, argument
Whose
is going
evidence is going on?
The plaintiff witnesses.
Plaintiff witness.
Witnesses.
Now it's,
Now the defendant witness goes on. My lord,
yes,
this,
so it's only for argument I am expediting.
my
This
lord,
suit.
my lord,
This
kindly
application-
appreciate, my lord, I make an application kind of liberty to, but there is
So if it is not expedited, then you will again file an application. Others will also file an application.
my lord, by
This
this order, my
application-
lord, these are been restricted. My lord, kindly allow me to permit the petitioner to make an application before the trial court to, my lord, this application is erroneously wrong. This has been filed by the sum of the court sharers. That is the mean to
That cannot be done.
Not by me, by the learned trial court hold that 19th July 2025, I made an application before the trial
This
court. This is
application
wrong.
under- Thank you.
Kindly
sir.
allow.
Thank you. This application under Article 227 of the Constitution 55 is the affidavit. Who has filed this application?
Which one is affidavit, not 57, 58 is the affidavit. So, but the pagination may
Oh,
be, my lord,
55.
wrong.
Yes, yes, I've got that. No, no, what is the wrong in the order dated 19th of July?
19th of July, if this is the wrong only, this application was not filed by me. They have been.
It has not been said that you have filed, that.
My lord, this observation finding by the learned trial judge in 12th August, kindly see.
Yes.
In addition to the above discussion, technically the petition also defective in nature as because the vocal outcome has not been accepted on behalf of the petitioners.
Yes.
No endorsement, the appointment advocate could be noticed on the fact of the vocal through the petition as it is the BRC signature. The submission made by the appointed advocate also carries the little weight in the absence of the action of the power. And the defendant is directed to be the diligent in his conduct and shall abstain from restoring to dialectic tactics. This is against me.
This
It's totally
I will record that you are not delaying. I will record your prayer that you want expeditious hearing. That will overcome this. This application
Next is same.
Next is same order. Thank you. Yes, call the fixed matter.
Fixed matter, order number 370.
So Mitra, sorry I kept you waiting.
No,
It was because of the previous day's backlog, Friday's backlog.
If your lordship wants me to come back on some other day,
No, I am ready because I could not take it up at 4 p.m. That is why I am telling you, because of the previous day's backlog, I could reach up to the last matter of Friday. Yes. Yes, this is which matter?
Well, the
Occupation charges during the
eviction and occupation charges, suit for eviction and my lord, consequence.
enhancement every 5 years.
Now, my lord, the stand taken by them, my lord, on the last occasion that they do not want to pay, my lord, even as per the enhanced rate. That is why, my lord, we said, my lord, kindly hear out, or your lordship wanted to hear out the matter, my lord.
Yes, because no, I wanted, because you also said that there is no possibility of any settlement if they pay at the market price. You said no, you do not want them to continue any further. That is why, if you want them to continue at the rate as per the agreement, then
No, that they also did not agree, my lord. They are sticking.
I was there on the last occasion. My lord, last occasion, discussion was.
are you agreeable?
I have to seek instructions, my lord.
No, no further instructions. Don't further instructions. That's Mr. Mitra is saying that you are not. So till now you do not have any instructions on that. Yes, Mr. Mitra.
Now, my lord, kindly once come to the, I had placed the impugned order before your lordship on the last occasion.
Yes.
Kindly come to the relevant portion, my lord, 2 pages, my lord, may I show. Internal page 11 of the impugned order, dated, my lord, 17th February 2025.
Yes.
Internal page 11.
Yes.
My lord, first, second, fourth paragraph, my lord.
Considering
the facts and circumstances of the case, the instant application under Order 13A of the Code of Civil Procedure and the written objection filed thereto, the annexed documents relied upon by both sides, the materials on record and the submissions of the learned advocate for the two contesting sides, it appears that an order can be passed under Order 13A of the Code of Civil Procedure when the court finds that a plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim. A summary judgment may be passed essentially when there is a clear lack of merit in one party's case and no compelling reason to delay the decision. However, for such an order, the court must inter alia be satisfied that there are no significant disputed question of fact to grant a summary judgment. The instant application has been filed within the prescribed time frame, that is after service of the summons upon the respondent defendant and before framing of the issues. Then, my lord, nevertheless, there are several questions that are required to be decided which cannot be concluded without complete adjudication upon framing of issues. It appears that mere admission by the respondent of the landlord-tenant relationship, the receipt of the termination notice, and the existence of the deed of lease are not enough to decide the suit summarily, as it is to be ascertained whether the termination notice was valid, legal, or sufficient or not, and whether there is any necessity of separate termination notice after issuance of a notice upon the lessee informing the time period within which the latter is required to make the payment of rent premium for the defaulted period and consequences of non-compliance of the same. It has to be adjudicated whether a composite notice regarding default as well as termination is legit or not, and this falls beyond the ambit of summary judgment.
Now the document has to be read. That is all, nothing further. Two documents, I would say, the lease deed and the notice. These are the only two documents, my lord, which are to be read. There cannot be, my lord, any requirement of any oral evidence on this.
Mr. Mitro, is it a suit
for
eviction on the ground of forfeiture?
Yes.
So if it is on the ground of forfeiture, whether that clause stands attracted or not, whether there is any default, that is only to be
on the basis of admitted facts.
Yes.
On the basis of
service of notice is not disputed.
Oh no, they have replied.
They have admitted.
They have replied.
So now whether there has been a forfeiture or not, whether you are entitled to enter into re-enter,
That is all.
and whether there has been this ground for forfeiture is that because they are taking the point of that COVID, whether they are entitled to that as a
only
framing a framing issue can be decided on that because legal issues.
It could have been, my lord, today. My lord,
there are two ways. One is with regard to the amount is one thing. If you want as a whole eviction also.
Yes.
So according to you, there is no disputed question of fact.
Lordship is aware better than me that, my lord, in a eviction suit under the Transfer of Property Act or even, my lord, under the, my lord, Premises Tenancy Act, after, my lord, the court, after, my lord, passing a decree for eviction can still, my lord, direct, my lord, a commissioner to be appointed to, my lord, ascertain the mean profit to be payable.
No, I am not on the mean profits.
No, I am on
mean
that.
Profits is subsequent.
I am till, my lord, the date of, my lord, issuance of the termination notice. They are liable to pay, my lord, as per the contract, unless, my lord, the forfeiture clause, my lord, which is embodied in the deed of lease, is attracted. So, my lord, I can today seek for a, my lord, I have sought for a decree for eviction for, my lord, occupation charges or, my lord, arrears of rent till the date of termination and thereafter for mean profit. 3 claims. Now, even if the mean profit, my lord, is required to be ascertained by, my lord, leading evidence, the rest too can be granted.
Yes, that is the thing which separate proceeding can be initiated under Order 20 Rule 12 for mean profits.
For mean profit, yes.
For that separate proceedings can be initiated. Absolutely. So it's only with regard to the eviction.
Yes.
And if it's the case of forfeiture, 114 allows them to deposit. So if they want benefit of that, they have to deposit.
They have not sought that. They have not sought that. Even
That
your
is why
lordship gave
that is why I want to see if they are willing to do that.
Yes.
So
not. They have not. It was taken up by your lordship last on, my lord, 18th of August.
So that is the relief which they could have sought for. So
now kindly come. Sorry.
Yes, yes.
Kindly come to the deed of lease.
Mr. Mitra, this has to be the document for the first time in a revisional court because we have seen a recent decision of the Honorable Supreme Court which says this should not be done at the revisional stage.
No, it's not first time.
to
It was there before the court below.
Yes, but the court below has not dealt with that.
Failed to exercise the jurisdiction.
Failed to exercise the jurisdiction. If I direct that criminal issues can be framed because there is no disputed question of fact only on these two issues that whether the notice is valid and what is the effect of that. Whether there's not a
issue means, my lord, a trial on evidence.
No, not on facts. Suit can be also because these are the two documents. If there is disputed question of fact is another thing.
Yes.
If it is on order rule 2, sub rule 2.
No, I will tell your lordship, my lord. 2 things. Deed of lease is not disputed.
Yes.
Creation of tenancy by the deed of lease is not disputed.
Notice also not disputed.
Notice is not disputed.
Yes.
Or, my lord, prior to notice, my lord, that they failed to pay in terms of the deed of lease, that is not disputed. And then the notice is not disputed.
Yes.
These are the 3 things.
So factually there is no dispute. Only on a point of law, whether on this you are entitled to the decree.
That, my lord,
it's a law point. Passing a decree.
That can be decided. My lord, kindly appreciate my position. Kindly appreciate
I appreciate that, but you have seen the recent decision of the Honorable Supreme Court, though that was under Order 7, Rule 11, says that
It's a different proposition. Yes, I was wondering, my lord, about this. No, it's not on this. Question is, my lord, only question is, my lord, whether the court exercised the jurisdiction or, my lord, failed to exercise the
yes,
jurisdiction. That is the only question. Today, my lord, the things, really two documents are to be looked into, the deed of lease and, my lord, the termination notice. Those are all. And, my lord, kindly in this connection, my lord, kindly keep in mind, my lord, the provision. My lord, this was not there originally in the, my lord, civil procedure code. Previously, my lord, for making similar application, my lord, we had to, my lord, rely on, my lord, Order 37. Now, my lord, a special provision has been, my lord, engrafted by the legislature, my lord, to expedite things. And, my lord, that is, my lord, kindly look into Order 39.
yes. Yes.
This is, my lord, by, my lord, the Commercial Courts Act, my lord, and for, my lord, commercial disputes, this has been incorporated.
This is before the commercial court.
Yes. Yes.
Yes.
Kindly look into. Scope and classes of suits to which the order applies, kindly come to Subrule 2. Order 13A, Rule 1, Subrule 2. For the purpose of this order, the word claim shall include part of a claim. Any particular question on which the claim, whether in whole or in part, depends. A counterclaim, my lord, it's not required. Notwithstanding anything to the contrary, an application for summary judgment under this order shall not be made in a suit in respect of any commercial dispute that is originally filed, etc., etc. It was not.
It was not filed under Order 37 suit.
No.
So that's the bar. If you file
That is the bar. That is the bar.
Yes.
Then, my lord, kindly, my lord, come to Rule 3.
Yes.
The court may give a summary judgment against.
So the next day.
Yes.
Virtually. Oh, I see.
Yes.
Rule 3. Grounds.
Actually, another court's link. Was
I
done.
see.
Yes.
Ground for summary judgment, the court may give a summary judgment against a plaintiff or defendant on a claim if it considers that the plaintiff has no real prospect of succeeding. Kindly omit that. And or the defendant has no real prospect of successfully defending the claim. This is the thing which has to be taken into consideration. And, my lord, as I have, my lord, repeatedly submitted before your lordship, that here, my lord, the defendant has not made out any case, my lord. The case, my lord, kindly consider the, my lord, malafide on the part of the defendant. First, they say, look here, COVID. Unilaterally, they say
2% of the
2%. Why 2%? Why not 3%? There is no explanation. Bangla dadagiri. I will pay you 2%, you have to take it. I did not take it. Continued, I filed a suit. Thereafter, my lord, or my lord, before that or thereafter, my lord, they started depositing. Ultimately, my lord, they started depositing and continued to deposit at the old rate. Even after the COVID was over, it was over by 2021 or latest by 2022. 2022, the enhancement came into force.
Even then, they did not.
No, they did not deposit the enhanced amount. There is no explanation. Even in 2025, there has been an enhancement. No, the further enhanced rate is not paid. This is, my lord, the conduct of the party.
Anything more?
These documents, my lord.
You want to rely upon a decision?
No, but before that, my lord, may I show you, Lord,
Documents.
the lease deed one?
Yes, yes.
My lord, kindly come to, my lord, page 66.
Yes.
It's a registered document, my lord. Kindly come to page 68.
Yes.
Clause 3.
This is the enhancement part.
Yes. 1st July 2019 to 30th June 2022, Indian INR 26,50,000. From 1st July 2022 to 30th June 2025, 30,47,500. And then from 1st of July till 30th June 2028 at the rate of 35 lakhs. Now this is one. Then, my lord, kindly turn the page, second paragraph.
Yes.
The aforesaid monthly lease rent as shall be applicable for each relevant calendar month as per the table above shall be payable each and every month by the lessee to the lessor subject to deduction of income tax at source as shall be applicable from time to time on or before the 7th of each such relevant calendar month for which it shall be due and payable without any abatement or deduction whatsoever, save as otherwise provided under the terms of this lease deed. Very specific.
So TDS they can deduct.
No, TDS yes. TDS provided rent.
Yes, it's on rent.
Provided rent, yes.
Yes.
Now kindly
lessee shall pay GST. All likes shall be applicable on the such relevant monthly lease rent, that is in words monthly lease rent reserved. GST shall be paid by the lessee to the lessor along with the applicable. So GST will be in addition.
Yes. Yes.
And they are deducting. No. GST they are paying to you.
GST payment করেছে? No, I don't think so. I don't think so. Unless I raise possibly, unless I raise invoice, my lord, they cannot pay. And my tenancy has I have terminated the tenancy.
You have to raise those bills. Oh, GST.
Kindly come to page 76, my lord.
But if the agreement contains Mr. Mitso, even then you have to raise a bill for that GST because the agreement says.
My lord, kindly come to my lord page 76 once.
Yes.
Clause D.
Yes.
GST on the monthly lease rent as per the applicable laws shall be borne and paid by the lessee to the lessor subject to the fulfillment of following conditions by the
GST
lessor.
invoice.
Yes.
Provides payment of paid to the authority which the lessor has collected. Subject to fulfillment.
And then, my lord, kindly come to, since the contract was not, my lord, alive.
You have not raised.
I have not raised any bill after, my lord, November or December 2020. When
after the issuance of the notice.
After the issuance of notice. Then, my lord, kindly turn the page. Kindly come to page 77.
Do you have the GST registration?
Yes.
It's because it says that.
There is no dispute about that.
No. It says that liability shall accrue prospectively for the date the lessor has obtained GST registration. Yes. That is. Yes.
They have paid, my lord, previously.
Yes.
Then kindly come to, my lord, page 77.
Yes.
Or, my lord, I will tell you. Kindly come to H, page 77. Major repairs such as leakage of roof, wall, busting, corrosion of electric cable, water pipes, weather system, and cracks in wall, save those pertaining to and falling outside of the demise
There is no
premises?
dispute with regard to this.
No,
Pierre.
these are when my lord, they can, my lord, try to deduct or stop.
I don't think they have made out any case with
No,
regard to
they have
that.
not. Then kindly come to the next page. K.
Yes.
Notwithstanding anything herein be above stated under clause 6 and 7, the lessee shall not be entitled to withhold the payment of monthly lease rent hereby reserved on any ground and or in any manner whatsoever or howsoever till such time this lease deed continues to remain in force, that is not terminated in terms hereof. But the lessor, upon complaint being made by the lessee by notice in writing with respect to any irregularity or lapses on the part of the lessor with respect to the provisions of clause 6 and 7, the lessor shall take all out effort to rectify, etc. This is that. Then my lord, kindly come to my lord, kindly come to page 80.
Yes.
Termination clause 8. This lease shall come to an end and or stand terminated in the manner as under Roman 2. Kindly come to termination by lessor. This lease may be terminated by the lessor even before the expiry of the lease term by efflux of time as stated in clause 8I.
Material breach.
Yes. And material breach has been defined, my lord. Now kindly turn the next page. Oh, I see. My lord, kindly, material breach is, my lord, defined in page 82. It's not very legible.
You have given a copy.
Yes.
You have given another copy.
I have given a, my lord, typed copy also. Devaj.
Yes, this is the copy.
I have a typed copy.
Typed copy also.
Material breach shall mean and construe the breach of any of the terms, conditions, covenants, stipulations, obligations, and representations herein so to be observed and performed by the respective party, and on the part of the respective party to be observed and performed by any part herein, and other non-breaching party gives notice to the breaching party specifying the breach or breaches of the terms, conditions, covenants, stipulations, obligations, and representations herein as the case may be by such breaching party, and set out and provide reasonable time, which shall not be less than 1 month, for remedy by such breaching party of the breaches complained of, and the breaches are not remedied by such breaching party within such reasonable time provided in the notice. Then
Have you invoked this material breach?
Yes, definitely.
So have you asked them to remedy the breach?
Yes.
That has been complied with. Yes. Yes. And force majeure clause is at page 81.
Kindly come to page 81. Clause 4. Termination under force majeure. In case the demise premises is wholly or substantially destroyed or damaged or at any time hereafter.
So this is the only reason.
If it is damaged or distracted.
So in an event, if the property is no longer in existence.
Naturally.
So they cannot be said that yes, you have to pay. So that is the only ground on which they will be exempted. So according to you, COVID-19 is not such a situation.
And my lord, yes. Payment of 2% means it was in use. And it is nobody's case that it was not in use. The entire property. The entire property. As I submitted before your lordship, my lord, it's a large property. Then my lord, kindly come to my lord their first letter, page 90.
90.
Yes.
Yes.
Page 90, kindly come to agreement, reference agreement to lease agreement executed such and such. Dear sir, madam, as you are aware, India and many parts of the world are
So they are treating this to be a force majeure, COVID-19 to be a force majeure.
and my lord, kindly come to the penultimate paragraph.
Yes, I am at 2%. I've seen that.
Given this situation arising out of an act of God,
Yes.
a force majeure event, we wish to inform you that we are only in a position to and willing to pay. No discussion, nothing.
It's
pay
their
this.
offer.
I'll pay you this.
This is their offer.
I don't accept. I respond to this, not accepting. Page 92.
So that can be only treated to be an offer. No acceptance.
No, page 92, my lord, kindly come to the second paragraph. Our contractual force majeure provisions as contained under clause such and such, referred under your letter, does not fall within the purview of clause 8584 of the lease deed, and therefore
So you have made your stand clear that it's
absolutely
not within that clause.
And then, my lord, kindly come to, I am, my lord, omitting, my lord, the correspondences exchange between, kindly come to page 133.
Yes.
Kindly come to page 134, second paragraph.
Material breach.
Under the circumstances, we on behalf
1
of
month.
yes, 1 month, and then the next paragraph. In case you fail to resolve, rectify such default by the date stipulated as aforesaid, please take notice that as desired by our client, the lease granted by the said deed of lease shall stand terminated on expiry of 2 months thereafter, and our client shall sue you for recovery of possession of the leased property.
So this is the 2 months notice as well
per
as
the-
that breach. 1 month.
Yes.
To remedy the breach is 1 month.
Month.
And notice for termination is 2 months.
2 months, my lord, that your lordship will find at page 80. Clause 2, my lord, the lesser
right to terminate 2 months.
Yes, the lesser shall have the right to terminate this lease deed with a 2 months notice in such case. And then, my lord, kindly come.
Provided the lesser has given a written notice of 1 month, failed to resolve.
Yes.
After the receipt of such notice.
Yes. And my lord, kindly come to their response, my lord. Page 137 is their response.
Now, only one thing.
Yes.
Page 80, second clause termination. Can it be a combined notice or it has to be a separate notice?
There is no bar. I could have issued the notice on the expiry of, my lord, the 1 month's period on the same day. Now, my lord, it's email served on.
That is there.
Served on the same.
Only one thing.
There is no bar that a separate notice has to be given, and possibly that is also not the defense taken in their, my lord, reply, subject to correction.
No, but it's a question of interpretation of that.
Absolutely.
Interpretation of that clause may not have taken. So
Very well. Very well.
So it says terminate within a period of 2 months notice, provided has given a notice.
Yes. Of 1 month to the lessee of such event, and the lessee has failed to resolve.
So a notice, let us think in another way. If it is a separate notice, let us consider.
Yes.
So 1 month notice,
Yes.
the object is
Yes.
that you ask them to remedy the breach.
Yes.
So that they will get time
For a month.
for a month
Yes.
to remedy that breach. So after receiving, maybe how this notice was sent?
By speed post, man.
So speed post.
Yes.
So after that speed post,
Yes.
it will take some time, maybe 48 hours, maybe 72 hours,
From
whatever.
that, my lord. From the
So,
receipt. From
yes.
the receipt.
So
Yes.
that is why, so it's a factual part. From that is 1 month, from the date of receipt, because they will get 1 month's time, not from the date of issuance of the notice.
My lord,
Has to be from the date of, because the object
I would, my lord, also, my lord, say, my lord, your lordship is, again, my lord, I would say your lordship is aware better than me, that, my lord, a notice for, my lord, shortage of time is, my lord.
That is, you are saying 106 for that, if that suit is after that.
Yes.
If suit is after that.
It's not required, but even I get that.
106 is one thing you are filing, because that's the statute, I think, says so.
The time period, the time.
A transfer of property act একটুখানি দেবেন? Yes, I have got.
বলবো যে পরে করছি কিলো হয়ে যাবে।
Yes, Mr. Mitra, this is in view of 106 subsection 3. Statute says, if the statute says, if it falls short, then if the proceeding is filed, that's the statutory mandate. So here it's a interpretation of that. So if that is,
May I come back on some other day? Well, I shall be very candid, my lord. I have an arbitration.
oh,
I said I will be candid, my lord.
how much time it will take?
15 minutes maximum. 15 minutes maximum.
Can it be after the vacation?
Kindly appreciate my situation. Kindly appreciate.
They will also, only difficulties last month, September, Mr. Mitra, I am making you a request, because for you, meaning not you alone, the members of the bar, because motions last month,
No,
we
I
have to be,
appreciate that.
that is why I am requesting you.
যে টাকাটা দিয়েছে সেটাকে এ করি। May I? Yes. May I submit this?
Which day you are free?
I am, my lord. I will make myself.
No arbitration. That is, however you free, Mr. Mitra, I know. So, or if it can be after that side of the vacation, it will be better, because last month,
At least, my lord, let them show some bona fide, my lord. Let them deposit, my lord. According to our calculation, 22 crores is outstanding. Let them deposit.
So how
not me in court, my lord, to show bona fide.
That is now, matter is being hard. I cannot, because that will, Mr. Mitra, will complicate. Then they will say this is under 114. I am doing that 114. That will complicate.
My lord, can I come back, my lord, next Monday, Tuesday?
Monday, Tuesday. Monday, Tuesday. Yes, how much time we will take?
I will take at least 45 minutes. আমি পুরোটা বড় না, তোমার একটু একটু পড়িয়েছো।
ওকে তো বলতেই হবে, কি করবো?
Monday তো monthly list বোধ হয় না? Monday is monthly list. Tuesday you are free.
I will make it.
Tuesday আছে ফাঁকা আছে Tuesday can keep it, but they will take 45 minutes. I do not know whether it can be concluded.
I will, my lord, I will possibly not take, my lord, 15 minutes also.
No, but they will take 45 minutes. So the thing is that if 45 minutes, it will be difficult this side of the vacation.
আচ্ছা, চারটের সময় মামলা ফিক্স করে একটু চুপ করে দাঁড়াবে, খুব ভালো হয়।
They will take 45 minutes. I do not know whether.
Can I come back at, my lord, on কবে হলো? Tuesday at 4 p.m. my lord. Gotcha. I am deeply obliged.
Heard Mr. Mitchell Lanet, senior advocate for the petitioner. First up, due to paucity of time, Mr. Mitchell could not conclude. List this matter on কবে বললেন সেকেন্ড না টিউসডে আর ওয়েডনেসডে
Tuesday.
2 তারিখ তো 2nd September 2025 at 4 p.m. Mr. Mitchell, again I am saying maybe
no
late
it's all right.
Because
I do appreciate, my lord.
Yes.
My lord, may I have my lords kindly to mention item number 17 when of today's list.
70. Yes.
17, my lord, 17.
17. Yes. What has been done?
When my lord the matter was called, we had prayed for my lord not today on the ground of unavailability of Mr. Jayanto Kumar Mitra, senior advocate.
Yes.
My lord had adjourned the matter. But when we inquired from the court officers, my lord, we heard that the matter has gone to the next monthly list. I was humbly submitting, my lord, if it could retain its position, my lord, if it could be taken up tomorrow.
Adjournment, I am giving.
Mr. Because
it's
of
difficult.
Mr.
Otherwise, I cannot proceed. It's for your benefit only.
My lord, motion stage, my lord.
Yes, all motions, sir. All are motions. This is no hearing matters.
The urgency is, my lord, because of an
That is why
interim order, my lord.
you have to start. That is why I requested your advocate on record.
Yes. He's
When he
quite
came-
competent to start, my lord. But because of the unavailability of Mr. Jayanto Kumar Mitra,
That's the difficulty because I am. If adjournment is paid for, I am all.
it was because of the personal ground, my lord. If my lord kindly,
ground, sir. Then I will not be able to proceed with this
I
matter.
appreciate, my lord. If my
If I have any other matter in the motion stage, I will not be. These matters, all adjourned matters, I cannot single out this. Then I have to keep all the matters prior to you, which were adjourned, all have to be taken prior to your matter. Then it will perhaps not reach.
May I humbly submit this, my lord, in that event, if it could retain its position in the monthly list only, we'll come back on Monday. If I could
Monthly
make
list-
that request.
Monthly list, this group of matters are in a separate class altogether. So it will remain there.